June 14th, 2007 meeting of the Planning and Zoning Commission. All rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay, the first thing on the agenda is the election of the vice chairman. But before we do that, I would like to say a few things. And this is about George Christopher, our former vice chairman. During his tenure on the Planning and Zoning Commission, George Christopher has brought about significant improvements to Indian River County. George took on the traffic issue with a great amount of tenacity. He identified traffic as our county's #1 problem. He researched what other communities had done regarding their traffic issues. He convinced the Board of County Commissioners to fund a traffic study and brought us all together to address traffic head-on. The results of that effort were quite a few new and revised land development regulations that will undoubtedly have a calming effect on this county's traffic woes. George has had a profound effect on how this county addresses growth and the results of growth. George thinks so much of Indian River County that even though he is a snowbird, he made most all of the meetings during the summer. He would fly back here twice a month at his own expense to attend meetings of the Planning and Zoning Commission. George's most recent endeavor on behalf of Indian River County is the Quality Development Workshop that we recently had. George has continued to work on this project even after Commissioner Bowden told him that she was replacing him on the Planning and Zoning Commission. Our county owes George a huge debt of gratitude for his past and current efforts. George, thank you. Now I'd like to entertain a motion to nominate George Hamner for the position of vice chair.
I'll move.
Okay, all in favor?
Aye.
Under discussion, can we get promise for an accolade like that? I mean,
Sure.
Bad chance.
Every time comes, it'll be better than that.
Okay, on the minutes, I know there's a couple of mistakes in there.
I had a question on the minutes, and Chris Morrow, I need your assistance on this. On page 3, 1, 2, 3, 4, down the paragraph where it starts that I asked the county plans for the road, Mr. Biddle said that the project would not be completed for a couple of years. Mr. Morris stated the widening of 66th Avenue would extend north and would include a left turn lane at that point. But Chris, if I remember correctly, you said that left turn lane would not be for 5 years?
Well, yes and no. It's kind of a difficult project to comment on because it's going to come in pieces. But we're going to be widening the intersection of 66th Avenue and County Road 510. When that widening is done, if we include the 4-laning of 66th Avenue to the north up through the Schumann-Barber intersection, then most likely there would not be a left turn lane for that project. If we don't include that 4-laning and it's built as a standard 3-lane section through there, then there would be a continuous left turn lane down the middle of 66th Avenue. But it looks like now that we've been working with the city and trying to get the funding together to do that 4-lane widening up through the Barber-Schumann intersection, in which case there'll be a median divider there and there would not be a left turn lane. So it kind of depends on the timing, but probably within 5 years, if the 4-laning goes through, there would not be a left turn lane there.
Okay.
I'm sorry to answer it kind of piecemeal like that, but it kind of depends on the timing of the widening.
It just makes the correction of the minutes a little bit more difficult, because at that point in time it was indicated that it would be 5 years. Now it's being indicated that there's probably a chance it'll never happen.
That's correct. If we do the 4-lane widening like we're planning and like the city and the county want to do in tandem, then there'd be a median divider and there would not be a left turn lane there. That's correct.
but if you do 3 lanes, it would be continuous if you improve the intersection, at worst, if you improve the intersection, you'll have a 3-lane intersection versus a 4-lane intersection?
Well, the reason I'm saying,
Is your mic on?
I don't know, I hope so.
yeah, I'm thinking that if we widen the intersection and don't do the 4-laning, then that area in front of that development would be in a transitioning area, and it would end up being without a median, which means there'd be a center turn lane for vehicles to get in and out of that development.
Darcy, can you figure out how to make the
Okay,
minutes
so
reflect that?
I think what we would like the minutes to say is that Mr. Morris stated that the widening of 66th Avenue would extend north.
If 4-lane, there would be no left turn lane, but if the intersection is improved, there would be a continuous turn lane, and therefore there would be a left turn lane in the improvement of the intersection
By default.
by default.
And that's in, what, a 3-year or a 5-year time frame?
That's in the 5-year time frame.
5-year time frame.
That's correct.
Okay, so that would happen in about 5 years if
Right.
it does happen. Darcy, did we make any kind of sense to you for rephrasing that?
Of course not.
Let's make this easy on Darcy. She's got a tough enough life as it is. Okay, Mr. Morris stated that the widening of 66th Avenue would extend north and may or may not include a left turn lane in 5 years.
That's probably the best way to say it. It may or may not include a left turn lane within 5 years.
Within
Because there's too
5
many
years.
variables to say that
Okay.
it will or will not.
I just wanted the Board of County Commissioners to have that 5-year figure in that statement, because it made it sound like we were going to have that left turn lane in time to support that project, and we're not. Okay, that's my change.
Does anybody else have anything? There is one point on page 8. The motion at the top of page 8 is reversed. The results are reversed. The 5 or 6 people voted for the motion, and Mr. Smith voted against the motion. Okay.
Wait a minute, to deny the rezoning request. Yes,
Do you have a problem with that?
6 members voted to deny the rezoning request.
Right, but voted against the motion.
Oh, okay.
Okay,
Voted for the motion. Mr. Smith voted against the motion.
right.
Got that, Darcy?
Okay, we have item on consent. I think what we need to do here is swear everybody in that's going to
Let me
speak.
move to adopt the minutes as amended.
Oh, I'm sorry.
Second.
All in favor?
Aye.
Aye.
Okay, it passes unanimously. Dorsey, could you administer the oath for anybody that's going to testify tonight? Huh? Right, we've got this quasi-judicial item. Is anybody going to speak on this item? Okay.
Raise your right hand. You swear or affirm that any testimony you are about to give is the truth, the whole truth, and nothing but the truth.
Okay, this item is Indigo, request for major site plan and preliminary plat approval for 116-unit multifamily residential development to be known as Indigo LMC Development, Vero LLC owner, Schulke, Biddle, and Stoddard LLC agent, zoning classification RM6, residential multifamily up to 6 units per acre, land use designation M1, medium density up to 8 units per acre. The density on this project is 5.998 units per acre, and it is quasi-judicial.
Thank you, Chairman.
Brian, I'm sorry.
Sorry, thank you, Chairman Bruce. I'm Brian Freeman, Indian River County Senior Planner. This application is for a project to be known as Indigo and is for major site plan and preliminary plat approval. And what's shown now is a zoning map of the site and the surrounding area. And as you can see, the site is zoned RM6, multifamily residential, and the surrounding zoning districts include a combination of A1 agricultural and multifamily, both RM6 and RM8 districts. And then also of note, to the southwest of the site is the East Village of Point West, and that's what is zoned as PD, plan development. And this is an aerial view of the site and the vicinity. And as you can see, the site is essentially former agricultural land. And to the north of the site is an existing church, and there's actually a communications tower on that church property, which is just to the northeast or just above the upper right corner of the site. You can see the shadow of the tower on the aerial. And then to the west of the site are several multifamily developments, and then to the southwest of the site you can see the back nine of the Point West golf course. And then to the east of the site is a mix of undeveloped land and agricultural land. Also, I would point out that in this area, 16th Street functions as the boundary of the urban service area. This is a view of the site plan for the development, and the project area is just over 19 acres and consists of 20 buildings, which will include 116 units. And this results in a density that is right at, or actually just under, 6 units per acre. And as part of the development, there will be a clubhouse and swimming pool recreation tract. Looking at traffic circulation for the project, the access will be from 16th Street. And in addition to the primary access, there is also a required emergency access, which is also to 16th Street. 16th Street and also 66th Avenue south of State Road 60 are currently unpaved roads and will be required to be paved for this project. And actually at this time the county has a road improvement project which is scheduled to begin sometime in 2008 to improve both of those roadways. And prior to any certificate of occupancy being issued for this project, it will need to be we'll need to have access to a paved road. And so unless the developer is willing to step up and do that themselves, then he'll be somewhat tied to the county schedule on that project.
I'm sorry, Brian, which two roads were they? 66th Avenue and what?
And 16th Street.
So they're going to have access to 66th or out to 74th, or what?
There's two ways to go to a paved road. You can either go west to 74th, or you can go east on 16th and then north on 66th. So, I mean, either one of those.
74th is paved, 66th is not.
But
That's
it's a
correct.
further distance to
Right.
74.
But what is paved between this project and 74th on 16th?
I don't think any of 16th Street is paved.
dirt.
Well,
Okay.
also there's that house that
And there's
is
a
a
house
little
that we
bit
have
to
to
the,
go around.
yeah, I mean,
through.
either go around or through. Has that been resolved?
I'm not too sure on the details of that improvement project.
Okay, that's okay.
The indication where they would have filled the ditch and go around her in some fashion, as I remember. But
That's what I remember, yeah.
But this project is much closer to 66th than it is to 74th.
But
Yes.
66th is not paved.
Right, so the 66th would have to, that's a half mile of 66 that has to be
Would have to be
paved.
paved.
I think that's the easier way to go, and also would probably function better as a paved road than to have it paved to the west. But that is something that this project will be tied to.
Either way, they've got to get to US Highway 60 vis-a-vis paving east-west or north-south on 66, right?
Correct. And one other thing to consider with the traffic for the project is that they will be making a contribution towards the State Road 60 improvement, and this would be the improvement of State Road 60 west of 66th Avenue, and that was based on the traffic study. Regarding stormwater management, there is one wet stormwater management tract that will be located through the center of the project. Looking at landscape requirements that affect the project, as the project is adjacent to the urban service area boundary, a 50-foot wide type B buffer with a 6-foot opaque feature is required along the site's south boundary, which is the boundary adjacent to 16th Street. And then along the site's remaining boundaries, a 25-foot wide type B buffer is required, and this would also include a 6-foot opaque feature. Other required improvements for the project include sidewalks, both along its 16th Street frontage as well as internally. And in addition, a little over 7.5% of the site area has been set aside as green space and or recreation area, and this includes the recreation tract with the swimming pool and clubhouse. The application also includes a request for preliminary plat approval, and essentially this is to create fee simple units or townhomes as opposed to condominiums. And each unit will be located on a small lot, which will essentially be large enough to include the unit and any exterior improvements adjacent to the unit. And as part of that, a final plat will be recorded prior to the sale of any units. Based on this analysis, staff recommends that the Planning and Zoning Commission grant major site plan approval for the project with the conditions listed in the staff report. And furthermore, staff recommends approval of the preliminary plat for Indigo.
Thank you, Brian. Any questions up here? Let's go ahead and open this up for public comment. Does the applicant wish to speak?
I have a few questions for the applicant.
Good evening, Joe DeBiddle, Schulke, Biddle, and Stoddard. Really, if you have any questions on the project, just to let you all know, we have been working with the county. We've been waiting for 16th Street. I'm sure my clients will tell you they've been hoping it goes through quicker, but we are tied to that, just as Brian said.
So you're waiting on 66?
That's
Okay.
that's what we're waiting for.
So you're going to help pave 66 as well, is that right?
We're going to try. So, but if you have any questions,
I have a question, Joe.
Sure.
On the entrance to the project, where the red arrow is, on the left is the main entrance, on the right is just the emergency entrance, right? Now, and the entrances are just about identical. I mean, they could be configured so that the main entrance could actually be on the right. And the reason I'm going into this is because where that red arrow is, where you have your main entrance, is a 38-inch oak, a 24-inch oak. You've got another 30-inch oak, another 14-inch oak. I can't read some of these other numbers. Whereas on the other entrance, you don't have the oak trees. Would you be open to changing your main entrance to be the one on the right and save those oak trees on the left?
those
The
set of
east
plans,
and
do you,
west.
Brian? Because I didn't think they were.
East entrance and the west entrance.
Okay.
I didn't think we were knocking down trees at the entrance. Well, no, those trees are being taken down for the 16th Street improvement. That's the only reason there.
Well, they're
Not all-
kind of,
not
no, they're
all
in the
of
middle of your, I mean, here, I have them highlighted on yellow here if you want to see what I'm talking about.
We see them from the aerial much better.
No, I'd rather you talk at the podium. Okay. Is that a reasonable request? And there might be a reason it isn't. Just so
Well,
you know.
and what I'm trying to say is I think it's a 38-inch. That's the only one that would be with the driveway, and most likely with the right-of-way construction, they're going to tear that down anyways. And the other one inside, although the road right there that's what they're proposing by the county. So all those trees are being taken out just to construct the road, not necessarily my driveway.
I guess what she's asking, is there any real problem to moving your driveway to the east entrance rather than the west?
I don't know.
Yeah, you've got to have an
We still have
emergency.
emergency
It'd be
access,
just
yeah.
kind of flip-flop the two. Is there a
But the other
reason
one
you're on the
can be a
west
lot
rather than
narrower.
the east?
The emergency entrance can be a lot narrower. And you might be able to save some of those oak trees there. Because we have quite a conglomeration of oak trees at that
Oh, yeah,
section.
I understand, but if you look at the roadway, the way it lines up, 16th Street, those are all gone. The only one is that 38-inch, but
And if you're going to pave 16th to 66, it'd be less for you to pave if you moved your main entrance to the east.
yeah.
So it'd be less expensive for you to even make this change than it would be to keep it the other way.
They're going to pave over the end of the property, don't they?
Yeah.
I just want to note that I believe all those oak trees in that part of the site are laurel oaks and not live oaks. So some of the really large, a 38-inch laurel oak is one that is actually near the end of its life cycle. So that was something that staff had considered when looking at the site plan.
Okay, it's just my thought process.
But I think either way, whether the entrance goes on the right or the left.
Just from the
I think
drawings,
is-
it doesn't look like there's any big deal one way or the other, but
Yeah. I think it personally to the applicant's favor to move the entrance to the.
Well, I mean, the county's going to build 16th Street. We don't care where our driveway is, so.
Okay.
And we actually had 2 driveways before, but we were isolated to one,
You're,
so.
you're telling us that those oak trees are going anyway because of the 16th Street,
Yes.
not because of your
No.
development. That's the
And
point.
whether I had a driveway there or not, they're still going to take it out.
That's the
to
point
do it.
you're making.
Yeah.
There are just there are a couple
It's
of
clear
them
zone,
building
it's-
that could, there's.
Some of them probably will stay.
Well, then in an effort for you to save money, you might just want to think about moving your driveway to the east, pave less of 16th.
I understand that.
Okay, thank you for the explanation.
Does anybody else from the public wish to speak? Seeing none, let's close the public hearing. Do we have a motion?
I'd move approval of the staff's recommendations with one caveat that the driveway be looked at whether east or west in order to save trees if possible.
I think that's a good idea.
Thank you, George.
Need a
I'll second
second? Okay, all in favor?
Could we have a little discussion?
Sure, go ahead.
I was wondering about the well. Is that abandoned?
Yes,
You said it was.
it's abandoned.
So it's a cap?
It
It has been capped, but not abandoned yet. So,
And
I want to explain
and-
the difference to the public.
that's, well,
Why don't you explain the difference?
Well,
Turn your mic on.
I got the mic on, but one is that it's no longer a well. You filled it up with concrete.
I believe it's just, it was actually flowing. Someone knocked it off. I think they just capped it for now. I don't think it's been filled in. Is that correct?
there's a formal procedure for capping a well, which he's referring to, which is in the staff report for acceptance, that you have to cap the well, and there's a procedure for that.
Right.
Actually, the well is addressed in the staff recommendation in conditions 1A and 3C.
It is a stipulation,
They'll be required to get a permit to plug the well prior to site plan release, and then prior to the first CO, the well will need to be plugged or abandoned.
right? But if it's not being used now, why is it not being plugged?
It's an old well that you've heard
It should be
Mr.
done.
Crumhout and others talk about, that it still exists in this county,
Right.
that are scattered throughout, and this is another one of
And
those.
they know about the well now, and it's pretty obvious.
Right.
You're just going to do it during construction.
Yeah.
Part of the
You're
construction.
not required to, but we are requiring it now, so.
And on the recreational areas, the 7% are normally clubhouses considered recreation? And
Yes.
swimming pool, and that fulfills the obligation?
Yeah, a clubhouse is a recreation improvement, such as a swimming pool or a tennis court, that can be counted towards the 7.5%.
And what they could have no swimming pool or no clubhouse and have it green and it would still pass?
Yeah, there's actually, I think, some flexibility in the way the code is structured on meeting that 7.5% requirement. It could be a preservation area or a wetland area. It could be some type of active recreation area or just a passive green area. There's different ways to achieve that objective.
So this is pretty much the minimum.
As far as the amount that they are proposing, they are just above the minimum.
Well, and just to let you know, this project actually, we submitted it before the new GAC requirements. We submitted a pre-app, of which we changed the whole project just to meet the GAC requirements, so.
Thank you.
But it doesn't meet the landscaping requirements, the new
Yeah,
landscaping.
it meets, well, not the latest one from a
Right,
month
because
ago, but
the
this is last
stormwater
year.
pond is pretty square, or T.
So,
Any other comments? All in favor?
Aye.
Aye. Okay, passes unanimously.
Mr. Bruce,
Yeah.
if you don't mind, just going back to the minutes, just for clarification, with Donna, the conversation you had with Chris about the previous project from last time.
Yes.
The, I don't want you to think that, is my understanding that, Chris, please, correct me, if it's gonna be 4 lanes, that they're not gonna be able to turn into our site. Is that correct? They're gonna send them down the intersection to make a U-turn to come back?
Sounds like it.
Well, that's what I'm saying.
Yeah, that's pretty bad.
But if it is 3 lanes, then we will have a turn lane. I just don't, want you to think that, the last comments that we were gonna be guaranteed a turn.
It's all your fault, or?
So, well, yeah, just want to clarify, so.
We just know that the people who live there are not going to be able to get home again.
Well, it's a loop. It's a DOT loop. All right, thank you.
Okay. Next item on the agenda is a public hearing. Consideration of proposed amendments to the LDR Chapter 911 Table of Uses for Industrial Districts. I know this is going to be a little controversial. There's going to be quite a few people from the public speaking. Please be orderly and do not repeat.
Mr. Chairman, can I ask you one? I read the PSC report, and in it, there was a lot of conversation about this, a concrete plant in a specific location. Would you please remind everybody, we're talking about a zoning change countywide, and, you know, I'm sure it's very sensitive, but frankly, we need to stay to the broad picture, not to any specific sites, good or bad.
I think you did that quite adequately.
Thank you.
Go ahead, Brian.
Thank you, Chairman Bruce. The item before you are proposed amendments to the LDR Chapter 911 Table of Uses, and this is specifically for industrial districts. And within Indian River County, there's essentially two different industrial zoning classifications, and these are IL, light industrial, and IG, general industrial. The IL district is primarily intended to serve limited manufacturing and industrial uses, while the IG district has a broader range of activities that are permitted within that district. And just to take a minute to look at where industrial land is located within Indian River County, first, this is an area or view of the North County area, and as you can see, there is some a limited amount of industrial land in the North County, and it's shown as both a purple color, and then what doesn't show up too clearly is a yellow color for the IG.
Magnify it. It's where Macho and,
Can we do something with the lights?
is that out by the gun range and where Macho Products is?
Can you do the lights?
Yeah.
Gun range.
Sure.
Yeah, Brian, why don't you just point to and identify each one? That's probably
Sure.
the easiest way to do
Well,
it.
essentially there's, you can look at these in three different, well, along the railroad, you've got mostly, or actually in the North County, all IL light industrial zoning, and then up in the Roseland area, there's some IL zoning, and then out at 102nd Terrace, you also have some more IL zoning. All the industrial zoning in the North County area is light industrial. And then this is a view of the Central County area, which is essentially the area between County Road 510 and State Road 60. And again, there's a lot of industrial zoning along the FEC Railroad, and here it is a mix of both the light industrial and the general industrial zoning. And then there's also quite a bit of both zoning categories in the Gifford area, just north of the airport. And again, this includes a lot of both IG and IL zoning. And then looking at the South County area, there is just south of the Vero Beach city limits along the FEC Railroad, you have both IG and IL zoning. There's a little bit of zoning, of industrial zoning along Oslo Road, right in the Oslo Park area here, and then out by the landfill. By the landfill, you have both the IL and IG zoning. And then there's some IL zoning out near the area of the State Road 60 and I-95 interchange. So those are primarily the areas where you find industrial zoning within the county. And regarding the uses that are allowed within the industrial districts, these are covered in the table of uses for the industrial districts. And essentially the uses are broken down according to the classification system of the NAICS, which is the North American Industrial Classification System. And essentially in each district, the IL or the IG district, individual uses are classified as either permitted by right or conditional type uses, which would include both administrative permit uses and special exception uses. And then all other uses which are not permitted or conditional uses would be prohibited uses in those districts. The proposed LDR amendment affects a group of uses which are paper manufacturing, chemical manufacturing, brick and tile manufacturing, glass and glass product manufacturing, cement and concrete product manufacturing, and other non-metallic mineral product manufacturing. And each of these uses include a large amount of outdoor process activities as well as outdoor storage. And of these uses, only one of them is really common within Indian River County, and that would be concrete batch plants. And in the county, there are 5 existing plants. All 5 of them are located adjacent to the FEC Railroad, and all 5 of them are presently zoned IG General Industrial. In addition to these 5 plants, applications have been submitted for 2 additional plants. One would be the Prestige plant, which would be located on 45th Street and is zoned IG General Industrial, and the second is for Ocean Concrete, and this one is on Old Dixie Highway in the North County area and is zoned Light Industrial. The proposed amendment will restrict the effective land uses to only the IG General Industrial District, and those uses would therefore be prohibited in the Light Industrial District. As was stated before, these uses are uses that involve large quantities of materials and outside storage, and these uses are all presently allowed in both the IL and the IG district. In short, the purpose of this amendment is to put these uses in the zoning district where they'd be more appropriately located, which is the IG district, and also the IG district happens to be generally further separated from residential areas than where the IL district is throughout the county. Staff's recommendation to the Planning and Zoning Commission is that they recommend approval to the Board of County Commissioners of the proposed amendment to the land development regulations.
Thank you, Brian. Any comments from up here?
Brian, remind me now, are there any existing plants that are currently inside an IL district?
No, there's no plants that are zoned IL, and there's also no plants that are located within any municipality in the county either.
Good answer, Brian.
Brian, can you put that map back up that shows the North County IL zoning areas? Is there an IG up there?
There's no IG zoning that's north of 510 in the county. I think the northernmost IG zoned area is in the vicinity of 71st or 71st Street, which is actually where Russell Concrete's north plant is located.
Right.
Are there any properties up there that are zoned IL that could maybe become IG, that would be appropriately rezoned IG?
Careful. I guess at this point, staff hasn't really examined, the rezoning potential of some of these sites, but I'm sure there are properties within the county that could be rezoned from IL to IG.
The reason for my question is I was asked by someone in the public to ask you if there were some properties up there that have been identified, and if staff would be looking at some properties that they thought might be appropriately rezoned to IG. Or my suggestion was that this person would just have to come in and see about getting his property rezoned to IG if that's what he wanted. That is probably not something you were going to be doing on your own. Is that true?
That's true. That's correct.
Okay, so I'm hoping that person is listening.
Brian, going south, what's the closest IG that's on the railroad track?
The northernmost IG zoning would be, looks like it's the area that's just north of 69th Street and probably extends all the way up to about 77th Street along the west side of the railroad.
Can you point to that?
I think it's up by Kennedy's United and up in that area.
So right there.
Okay.
Okay, any other questions up here? Seeing none, I'm going to open up this for the public hearing. Let's start over here. Does anybody wish to speak?
If they have to.
You need to state your name and address for the record before you start speaking. No, there's no swearing in on this, is there? It's legislative.
We sent in a PowerPoint thing to You have it set, okay, for some reason you wanted to bring up the food trucks.
I did want to bring this.
Okay.
No. I wanted to bring this.
Okay.
And then
Stop
this.
Ocean
Yeah.
Concrete, then just whenever you want, ask her to bring it.
Thank you, Commissioners. My name is Jeffrey Smith. I'm an attorney with the law firm of Smith & Associates from Tallahassee, and I represent Ocean Concrete, Inc. and Mr. George Mabe. I have several legal issues I'd like to discuss concerning this proposed land development regulation amendment, and I think as I go through this today, you may hear some frustration, and there's good-
Are these legal issues that are spread across the entire county or one specific site?
These are legal issues, Commissioner, that I think go to the heart of whether or not it is wise to adopt a county-wide policy, a county-wide amendment in response to efforts by a group of citizens that wish to stop a particular project. And that is the heart of this issue. And we can't ignore it. We can't just put blinders on and say, let's not talk about reality. Let's ignore reality and pretend that that's not what's going on here. And we can't do that. I'm going to be brief. I have about 3 legal points I'd like to make, but I don't think I can do that and say, let's pretend the world isn't what it is.
I hope you're good.
Okay, thank you. And let's make no mistake about it. I think there was a slide up a minute ago. This land development regulation process, in my opinion, having looked at the record, is simply an effort by a group of citizens to manipulate, abuse, pervert the land development regulation process because of concerns over a particular site. I don't know if we can put my slide back up, but that's a slide from the proponent of this particular, and I think there's a following slide, that is a slide from the parties that petitioned the county commission to initiate this land development regulation process. If you'd go to that next slide. And on their website, this is their website, Stop Ocean Concrete. And on the website, if you'll notice, the strategy, the plan of action is to work to have the zoning and land use plans changed to prevent this from being an ongoing problem. That is what initiated and brought us here this evening, is the effort by this group of citizens to stop this particular project. And since that time, the effort has been a race to the finish line to see if they can get to the county commission, get this enacted before the application or permit process is completed by Ocean Concrete. And in the process of racing to the finish line, we're bypassing normal channels. We're bypassing careful and thoughtful analysis about whether this is a good countywide policy. We bypassed the Professional Services Advisory Committee because they did not have a quorum present, and rather than go back and get a quorum present where some good ideas were brought up by members of that body, we simply raced on to the next step in an effort to get this before the commission. We have requested that there be public workshops on this particular countywide policy. And what we would propose is that there be public workshops where we can dig in and look at, number one, is there really a problem? Number two, what are the land availability implications of making this change. What land is available? How big are the parcels that are available to meet the county's future land use needs in this area? Those are the types of things that can be ferreted out in a true and fair public workshop if the process wasn't simply being used as an effort to defeat a particular a project. If you'll look through your agenda packet, it's interesting that despite the fact that there are multiple uses that would be affected by the change, the only thing that's talked about is concrete batch plants, and there's material only on concrete batch plant. All the other industrial classifications that would be affected are ignored. And we think the reason for that is quite simple, and it's because this isn't about countywide policy. It's about a particular project, and we say that project ought to be decided on its merits under the regulations that exist and in a fair and objective way, and it would be approved. And that's what the opponents know, because my clients bent over backwards to make sure that everything meets code, everything meets the current regulation requirements.
Jeff.
We would urge...
Jeff, could I interrupt you for just a minute?
Yes.
You're raising some questions that I want to ask council about. This is turning into, in effect, a determination on a specific project, even though this is a question on LDRs and the change in an LDR. Here's my question. If the commission voted this evening to change, would it affect the application of Ocean Concrete?
Well, first I want to say that this is strictly a process to review the current regulations in the different zoning districts. This is not about Ocean Concrete. It should not be about Ocean Concrete. This should be a general policy-making decision. This is why this is legislative and not quasi-judicial. If we were examining the Ocean Concrete, we'd have to make it quasi-judicial and have to run through the steps. The action you take tonight will obviously go to the Board of County Commissioners. The way I think I read the current law is, if the law changes, it applies. It will apply to Ocean Concrete. Ocean Concrete will either have to follow the new regulations, or they would have to make a vested right determinations that would allow them to be sort of grandfathered in to the old regulations.
All right, thank you.
And that's a very detailed, factual-oriented process.
But that's a legal determination.
It's a legal determination.
That affects us, but doesn't really affect the decisions on policy tonight.
Exactly. This is policy. That's quasi-judicial. It's very factual intense. You're looking at several different aspects to see if they are entitled to this grandfathering, and that should really, to the best of your ability, not influence your decision tonight.
Right.
So again, we're back. I'm sorry. Again, we're back to what George said. This has nothing to do with a concrete plant. Their vested rights is their problem, not our problem. Right now, we're just making policy.
You're making policy.
It may become a county problem, but the reality is that that's not. If we're looking at something tonight, the real reason is whether or not we want heavy industrial or uses or some uses in IG versus IL. Right. And that I don't want to take anything away from anybody in the audience, but that's what at least I'm going to be looking at.
Commissioners, and my point here, and I'll move on to my next point, but my point here is that this process has other policy implications for the county that go beyond just the issue as you phrased it. It goes to the question of, is the county going to allow and condone the tactic of, let's change the rules at the end of an application process because we want to defeat a particular project? And let's assume that's successful. Let's assume that these fine citizens defeat Mr. Mabe's right to utilize his property. And Mr. Mabe takes his lumps and says, you know what? I'm going to look at what's left available to do with my property. And one of the things I can do under the existing use is to have a trucking terminal. That's an allowable use. Now the citizens are up in arms and say, oh my God, they're going to do a trucking terminal over there on that property. You know what? We better take that out of the allowable uses.
I don't believe
This-
I'd have said that. but
This is,
okay.
no, I'm not saying that's what you said. I'm saying it's an issue for the commission to consider whether this is the type of policy we want to establish for the county, is to allow people to manipulate the land development regulation process, just like it says up there on the Stop Ocean Concrete sign posted on the website. That's what we're going to do, and that's what we are doing.
Can I interrupt you a second? Brian, Bob, Stan, where is Ocean Concrete in their process?
Ocean Concrete submitted their application in December of '06 and went to TRC in late December of last year. And staff's TRC comments were sent out in early January. And at this point, Ocean Concrete, or their engineer, is addressing those comments that staff issued back in January and is to be resubmitting at some point. I don't know when that resubmittal will come in, but that's currently where it is.
Okay.
Right.
Go ahead.
I'll wrap up that first point is simply that I think to allow this is bad planning, and it will be violative of my clients' due process and equal protection rights. The second point I'd like to make that I think is a policy consideration. It will go to Mr. Glenn's point about vested right determinations, and that is, I believe that if the county commission proceeds with this proposed action and applies it retroactively to applications such as my client's application, that there is you're buying a Burt Harris Act claim, you're buying litigation, and you're buying a exposure to tens of millions of dollars in liability if this was to be applied retroactively to under the facts of the case. And the facts are that it didn't just get applied for in 2006. There's been a prior application, and my client has spent millions of dollars to get to the end of the line, and now is being told at the end of the line, we're going to change the rules. The courts have looked at that, and I would say there is not a more compelling case. I have reviewed the cases on vested rights. I have reviewed the cases on equitable estoppel, and there is not a more compelling case for application of that doctrine than what Mr. Mabe has in the investment of time, resources, effort to get to where he is. The other issue, a legal issue, that arises in making a vested rights determination is whether a county can be exposed to claims of a bad faith process, and that goes back to my earlier point. This whole thing is riddled with obvious manipulation of the process by citizens to try and defeat a particular project. We have the city of Sebastian passing resolutions to defeat the project. We have county staff telling my client that they need to, regardless of the fact that the city has no jurisdiction over this project, that they must address the city's concerns. We bypass the normal channel with the Professional Services Advisory Committee. It begins to smell bad. And we're racing to the finish line instead of conducting a thoughtful analysis. The final point I'll make is this, that not only do we believe that the process is being abused and in violation of my client's rights, not only do we believe that it is exposing the county to potential liability under the Burt Harris Act, but it's also inconsistent with the county's comp plan. It's not thoughtful land use planning. There needs to be a thoughtful analysis of what are the implications of making this change. What are the lands? First of all, there needs to be an analysis of, do we have a problem? Is there really a problem existent in the Indian River County? And we need to analyze that and look and say, where does that problem exist? Is it an air pollution problem? Let's look at the science on that. Is there a water pollution problem? Let's look at the science on it. Let's not give in to the clamor of the crowd and say, well, we have a group of citizens yelling an awful lot that this is a bad thing. Let's just change our land use regulations and that'll solve the problem. We need to look, is there a problem? And if we do identify a problem, then the thoughtful, objective, fair thing to do is to look at what are the options for dealing with that problem. Is the only option for dealing with that problem to change the land development regulations to preclude this use? Might there be an option, for example, that was discussed at the Professional Services Advisory Committee of a special use? Might there be, for example, let's base it on science and say, if you get more than 500 feet away from a concrete plant, if that's the real concern of a concrete batch plant, there are no air pollution concerns, there are no dust concerns, there are no noise concerns. If that's what the science tells us, then might an option be, well, in order to qualify, you've got to have at least a 500-foot setback. Or if the science says that's 750 feet, then let's have a 750-foot setback. Or if the science says it's 2 miles, then let's have a 2-mile setback. But let's base it on reason, let's base it on data and thoughtful analysis, and not just on an emotional outcry from a group of citizens that has some aesthetic concerns about having this type of facility that's actually, if we could go to some slides, I think maybe Mr. Smith, when he comes up, would put those slides up, but we have some slides to give you a sense of how far away from other properties that the project of concern really is. But
Mr. Smith, you did say you were going to be brief.
I am, and I'm wrapping up right now, and I appreciate it, Commissioner Bruce. I'm sorry I tend to get wound up about this, but it's because I think, in all honesty...
But you're starting to repeat yourself.
In all honesty and fairness, I'm going to wrap up right now. I think that we need a thoughtful plan, and I would recommend that this commission do 2 things. First of all, I think that the commission should set aside a time where we can really dig into these issues and bring forward experts on the various topics and present them in an orderly, logical fashion, whether that's before a discussion before the Professional Services Advisory Committee or another forum. Really makes no difference, but have a thoughtful and fair and reasonable debate on the issues and look at them in detail. And secondly, if the commission's wish is to send this on to the commission, the Board of County Commissioners for adoption, I would just strongly urge that it also go with the recommendation that it not be retroactively applied to applicants who have spent just untold amounts of effort to get to where they are and have the rug pulled out from under them at the last minute. And so those would be my recommendations. I thank you for your time.
You're welcome. Next. Please state your name and address for the record.
Todd Smith, 121 Hinchman Avenue, Sebastian, Florida. I'm the engineer of record for the project we're not supposed to mention. And I'm also a member of the Professional Services Advisory Committee. I've been a member of that board since its inception in 1991 and have reviewed many ordinances over the last 15 years proposed by staff. And I think you'll find my comments go to the heart of the matter as far as this ordinance as a whole and our county as a whole. Can you switch to the next slide? When this ordinance first started and came before the advisory committee, and Mr. Smith already touched upon the issues of whether a quorum, there was a lot of members from the public as well as members of the board that there was a lot of good points brought up at that meeting. And the ordinance was tackling so much stuff, it was quite impossible for the advisory committee to come to a consensus of a recommendation in the short period of time that they had. But over the past 15 years, I cannot recollect a time where the advisory committee has not sent a recommendation to this board.
Mr. Smith, though, but at the advisory committee, how many people were deemed conflicts of interest?
Yeah.
There was.
I mean, there
was 5 people deemed conflict of interest of 11-member board.
Right.
Right. But the issue,
So I don't, the quorum I understand, and I think
and-
most of the people up here understand.
and I understand that, but what my point is that when an ordinance of this much, that there's this many issues, and I'll compare it to the landscape ordinance from back in February, March. The time was taken for, if there's a problem with because of members and their interaction with a certain project with the advisory committee, there was, a public workshop could be set for professionals that don't have conflicts, that ink could be put in. The project can, over the past 15 years, the advisory committee has dealt with many issues that have come back for month number 2 for the commissioners to rehash technical points. And it was always my understanding that the charter of that committee, the purpose of that committee, was to assist the commissioners in working out some of the finer technical details to come up with a consensus of a policy or an ordinance that, if there is middle ground to be found between staff and private sector and public, that something like that would be formulated out of that. So, and I think that's, it kind of ties into what Mr. Smith was saying about there's other processes here that if this committee feels that this ordinance does affect so much that it could benefit from a public workshop, that's a tool that is available. And if you could put
my understanding of that meeting was that you all came back and said, there are possibilities on special exceptions, there's possibilities on PDs, but there was no consensus reached, probably because there was no quorum and there was a lot of conflict of interest among all the members of the committee. And even in your own slide, which you just cleared, it said the focus was on Ocean Concrete, not on the pros and cons on overall for the county as a whole.
Right.
So, the Public Service Commission has always advised this board, and we relish your support and your thoughts and et cetera. But if you can't come up with something, then it gets laid in our lap. And the PSC, that's what's occurred now. It makes me wonder. I guess we're just going to have to decide tonight on the county, not on Ocean Concrete, whether this is good or bad. Whether we want paper mills, we want heavy industry listed in light industry areas.
And I understand, and my point again is just that
and I, for one, have always been a big proponent of property rights, and I understand the Burt Harris rights probably as well as anybody up here. So that's why I asked your attorney to focus on the whole, not on one specific project, because that really, the project at hand that people are complaining about, we understand, but it's not our problem. We're looking at the county.
Right, and
we haven't got anything from Ocean Concrete.
Let me pause here 1 second. Bob, how many times is PSAC locked up, in your opinion?
They've done it several other times.
Okay.
Yeah.
And those things...
This is not the first time.
This was not the first time.
Okay. Just wanted to be sure about that.
Matter of fact, don't they have a standing rule, the PSAC, that if they do, that they just don't send any recommendation forward?
Yeah, they're maybe more so than other committees. They haven't maybe spent as much time and effort to reach a conclusion. Like I said, in several other times in the past, they have kind of found themselves deadlocked and determined.
But, good or bad, we've asked a professional group of people, all of whom work for a living, and they may or may not have more or less conflicts.
Correct.
More conflicts than others, but we want their advice, and that's the makeup of that committee lends itself to the conflict.
I think they did give some advice. In the form of comments. It wasn't a recommendation.
There was a lot of comment, and they had motions, and there was a lot of discussion about it, but it was really more specific than it was countywide. That was the only thing that I didn't like.
Mr. Bruce? Go ahead. Wait, just 1 second.
Mr. Glenn, is it a legal requirement to have a reading or a recommendation from the Public Service Commission before we make is it even a legal requirement that it go in front, or is that just a courtesy that we extend?
Well, it looks like from the resolution creating it that it's supposed to go in front of them. But as has happened in the past, if they don't give you a recommendation, that might be the recommendation that they can't come to a conclusion. I think there's a process that they're supposed to go through, but
My point is that that's not a requirement, a hard requirement that they give us a recommendation.
no, I would say that's not.
And
We've
in
had
standing, we've had a many a time before that they have not. And
We've
that's my
also
point.
sent P&Z has had times when we've sent no recommendation to the Board of County Commissioners because we couldn't agree.
Right.
So it's not unusual.
Exactly.
Or
Okay.
we've sent recommendations and they don't agree.
Go ahead, Todd.
Okay, so anyway, but I understand your points, but my points is that there are 31 uses being proposed with this ordinance to be restricted from the zoning. I would think that that would be a quantity that all of those industries should be discussed and the impacts. Let me read something that I found quite ironic, because earlier when the
Can
commissioners
I
were
interrupt
asking...
you just 1 second? I think that's what we're doing right now, is we are discussing it.
Okay.
So,
This is a letter, when the questions were about parcels available in the North County area of industrial lands. This is a letter that was issued back in July of 2004 from the Planning Department to Prestige Concrete in their original application. Staff recommends a different location for the proposed concrete and block plant. There are sites in Sebastian, Fellsmere, and northern Indian River County that are zoned industrial and more suitable for this heavy process and truck use. That seems
can
to
I
be
interrupt you a second? Can you come a little closer to the mic, because you're not
Did you hear
coming through.
what I read?
I heard it, but
Okay.
it's going out over.
That seems to be a little contradictory to what was told earlier about available IG parcels north of County 510. The staff even made the comments that sites in Indian River County would be those along the FEC Railroad, which would make delivery of raw material easier. According to the questions that were answered earlier tonight, there are none. So this is an important point about when you're restricting these uses from the IL zoning, and the questions about how many IG parcels are left out of these 31 uses. I believe staff did an exhibit that was given to the advisory committee of parcels of IG and IL zoning over 5 acres in land, which would be a typical threshold for projects of these sort. And out of those 20, I believe there was 27 of them, 3 of them are IG, 24 of them are IL. So when we talk about the ordinance and its impacts, if you're going to restrict all these businesses from IL, and now we're not even talking about the North County area, how many IG parcels are left for these businesses to come into the community? If we're going to make a decision that these businesses are not important to our economy, then the issue's resolved. But if this board feels that these issues are important to our community, then this ties into this ordinance about where is the land available most appropriate for these type of businesses to go to. If you could press the next...
Before you change that, what I notice missing up here, we go from printing inks to explosives, but we don't have anything about asphalt plants. Why is asphalt plant left out of this? Was that a conscious decision, or is it?
No, those already are restricted to the IG.
They are restricted to IG.
Yes.
Okay,
yes.
thank you.
If you could press the next button on the slide, please. When you look at the land development regulations as they exist today, there's obviously been a lot of time and effort by many educated people over the last 20 years developing our code book. And again, when you start talking about just carte blanche restricting uses from, in this particular case, IL zoning, and start squeezing it down into small available parcels, there are other mechanisms that exist in our code book, such as the sound ordinance chapters, air quality chapters, the landscaping chapters, buffering, different scientific parameters that do exist in the code that can be used as tools to regulate projects on a site-specific basis to allow uses in different areas instead of just saying, no, let's restrict all of these. And if you could press the next slide, please. I think the big shortcoming of what's before you this evening is that if you look at the IL and the IG and the definitions, and many different agencies define them different ways. The traffic engineers define light industrial as projects that generate less than 2,000 trips. Heavy industrials projects that generate greater than 2,000 trips. Each scientific community has their own definition, but I don't think a proper definition between the two zonings has really been presented to this board. There are parameters that can be used if the public is given an opportunity through a workshop, through whatever mechanism, to come before this board with a more sounder basis, more technically based set of criteria that can dictate not only those 31 uses, but maybe all industrial uses to both IL and IG. Air quality, smell, traffic, noise, production volumes, residential impact, they're all good parameters that could be used, and there's no doubt in my mind between staff and the private sector that parameters could be set up in each one of those categories, and whether you send these projects into the special exception format or an administrative permit format, those other procedures currently exist in the code book. If you could switch to the next slide. As I reviewed the agenda packet before you tonight, it seemed that the majority of information that was given to the board is air quality, and again, it seemed like all it was about was the concrete industry. I didn't see any exhibits in there about the glass bottling industry, and if any of us have ever been around a tile cutting saw, we all know how much dust that throws up into the air compared to what's coming out of a concrete plant. So, my question goes to, where is all the data on all of these businesses? And when you talk about air quality, if you're going to use that as a parameter, if you say that's a problem, is there a possibility I could get these two aerials on an overhead or something? The chart that I've put up here is basically a three-quarter mile.
Yeah. Let me stop here real quick. One of our commissioners is coming in. Welcome. Forward. That's okay.
Rookie.
Yeah, we'll introduce you later.
I'm trying.
Rookie.
Mr. Smith, you're going to have to start wrapping this up.
Okay, I just have a few other comments. What I've put up here is a three-quarter mile radius around the existing concrete plants in this county, because there's all this information in your agenda packets about air quality, and this is a dirty business. It's going to pollute our atmosphere. And of the parcels that are up there, the 5 parcels that are in our IG zoning district are exposing, they range from 76% to 106% more residential population than the particular IL zoning in the North County. So if we're talking about, well, in this one particular use, concrete, the air quality is what's making this, why we're considering this as being restricted from IL. What about these projects that we're saying we need to push this into the IG because of air quality, but we got 2 concrete plants sitting in downtown heart of Vero Beach, Rinker Materials and Russell Concrete, that you can see 5,500 people around that.
Can I stop you there? I thought we had established that there were none inside of any of the cities. Is that correct?
None in IL.
No, in IL.
These are all in IG.
IG.
That's what my point is.
Are there any IG concrete plants inside of cities?
Rinker.
No, Rinker's not inside.
That's not the city limit.
Street is a cutoff from Vero Beach.
So you misstated on that.
There's 2 plants down on 10th Avenue and 12th. Rinker and Russell Material have concrete batch plants.
I don't believe those are in the city.
They're not in the corporate limits, but they're in, say, the...
Yeah, I meant downtown city generically. I didn't mean in the corporate limits.
Just wanted to clarify that.
They're in the unincorporated area. But they're in the IG zoning. And, where's and I don't personally believe air quality is a problem, but if there's this concern over air quality in this business, Where's the concern for the majority of population that's being affected by these parcels in the IG district? I would think that that would be an important parameter for the board to consider. And again, this is another scientific parameter that could be used for all of these uses. If there's an effect on residential, our population, it doesn't necessarily have to be the adjacent property. Air pollution doesn't stop at the property line. Maybe it's something a half-mile
Okay,
radius.
let's
mile
wrap
radius.
this up and go on a little bit further.
If you could switch to the last slide, please. And just again, having to do with air quality, and the only reason I'm talking about that is that seems to be the only documents that have been submitted to you tonight. And another example, auto paint body shops, one of the most unregulated businesses there are, with the potential of air quality issues, and marine boat repairs. Both of those uses are allowed in the C8 zoning districts, which is even more passive than the IL zoning districts. Hopefully my comments, go to the heart that you don't have the total package of information. There's conflicts here on what's trying to be purported as a problem, whether it's air quality, whether it's dust, noise, whatever, that time needs to be given in some mechanism, through a workshop or through a recommendation to the commission, that maybe there's more here that needs to be studied than what's initially meets the eye. Thank you for your time.
You're welcome. I guess one comment here, and that is what we're doing here is tweaking these LDRs. We have done this numerous times in the past where we've recognized that a certain feature in the LDRs doesn't really belong in one category or another. Next person up. State your name and...
Good evening. My name is Wayne Rilko. My address is 447 Southeast 3rd Street, Melrose, Florida. It's a little community just to the east of Gainesville. I am a faculty member at the University of Florida Department of Civil and Coastal Engineering. I took that position back in 2003, and just to give you a little bit on my background, since you all don't know me, prior to that, for about 19 years, I was the chief engineer and vice president of engineering for a large company on the west coast of Florida that was involved in concrete batching, asphalt production, and mining. I was our environmental permitting person and compliance engineer also. The reason why I'm here, one of the main reasons how I got involved in this, one of the gentlemen who was providing some logistics as far as financing and so forth for Ocean Concrete, and I'll limit my conversation to being generic to the LDR amendment proposed 9/11. One of these gentlemen I've known since I was in junior high. We've known each other since junior high, so that's why I got involved in it. I'd like to just shed a little bit of light on concrete batching and maybe dispel some untruths. Concrete batching is certainly not cement production. Cement is dry and it's dusty. Concrete batching is taking a small amount of cement, around 10 or 15% cement, mixing it with water and sand and rock or aggregate. It's a very important distinction. What we're looking at is a concrete batch plant is very similar to what you would do at home. Go to one of the home supply stores, get a bag of Saccrete, open it up and mix some water with it, and in that bag of Saccrete is the cement, the sand, and rock. And when you open up the bag, maybe you get a little dust out of it. Well, if you took your vacuum cleaner, you could suck up all that dust, and that's basically what a batch plant does. Excuse me. It has a dust collector. That's what we call point source pollution, and the dust collectors on the batch plants are about 99% effective in removing particulates. Just like your vacuum cleaner at home, it has bags, and what would happen is that anything that's collected in the dust collector is returned back to the cement silo. Very important other distinction, too, is there is outdoor storage of the sand and rock aggregate. To batch concrete, you need to make sure that the aggregate is kept in a moist condition. In other words, all the voids in the rock are filled with water. There's also a coating of water on the outside of the rock in order to batch the concrete properly. So we're looking at a couple different things here, and I want to address these potential problems, if you will, or concerns. We're looking at the dust collector as a vacuum cleaner, taking care of any point source discharges. We also hear the term fugitive dust, and if the wind blows, will we get dust off the stockpiles? Well, in this case, certainly not, being they're kept in a moist condition 24/7. Also, another source of potential fugitive dust would be truck traffic coming in and out of unpaved surfaces. We certainly can eliminate that by having all impervious surfaces where the truck traffic will be. This is important for a number of reasons. A lot of other yards don't have that, and that's where you get the fugitive dust. Maybe in a stockpile of aggregate where you're not keeping it in a moist condition, certainly that same situation would apply. The air pollution regulations, that are formulated by the EPA and delegated to the DEP, that's the Florida Department of Environmental Protection regulates air permitting for batch plants. They also regulate permitting for cement plants. Cement plants would be called major sources. There's also a category underneath that as a minor source. And a concrete batch plant really requires only a general permit. The FDP recognizes that these aren't big polluters. They recognize that during their review of a permit application that the technology is such that these plants are equipped with dust collectors. They know their efficiency. Their efficiency is nearly 100%, in many cases 99.9% effective for removing particulates from the atmosphere. So with these safeguards in mind, a good designed plant will have the dust collector taking away the point source and paved surfaces and wetted stockpiles addressing the concern of fugitive dust. There are a limited number of sites for doing this type of work. One of the, as you saw on a number of the maps, the railroad siding is certainly makes some parcels have a lot of utility for doing this type of work. In a batch plant, you have to bring everything in, and you haul everything out. You batch it, then it goes back out. Having being adjacent to a railroad will eliminate the truck trips by approximately 50%. Bringing in rock by rail, bringing in sand by rail, and bringing in the cement by rail cuts down this traffic roughly in half. This is something that, there just aren't many of those sites available. And you all know your county very well, but, in traveling around the state, you could see that they just don't exist. The railway and siting of these type of plants has been historically along the railway. You go along the East Coast, and you could see many of the towns and cities where are the batch plant, the block plants, and these type of uses located along the railroad, just for that reason, for transportation, and also for talking about air pollution. The biggest source of fugitive emissions is car and truck traffic. It's a far bigger source than anything that the batch plant or that type of industry puts out. Speaking of other uses, I limited my topic on concrete batching. That's what I'm an expert at. I recently wrote a training manual for the Department of Transportation through the University of Florida on training people how to batch concrete for Florida Department of Transportation projects. I don't know much about glass making, chemical manufacturing, and all the other laundry list of industries that are potentially affected by a change of the ordinance that you're looking at today. But I would suggest that not only the people that are affected by the batch plant people that would potentially be affected by a change of policy and a change in the LDR, but the other people that would be affected, the landowners and the people on this list have an opportunity to participate in this process. It just seems to me that we're trying to rush this through. What about some workshops or things of that nature? I certainly would participate in that and share any knowledge that I
Sir,
have.
you need to start wrapping it up. You're starting to repeat what other people have been saying.
Yes, sir.
And
Yes, Mr. Chairman. I realize you have a lot of other people who would like to speak. In conclusion, as just I was saying, I would be glad to participate with staff in workshops and things of that nature to bring all the information out so that a good decision could be made. Thank you.
Okay. Let's switch over here to the right. Does anybody wish to speak? Go ahead. Yes. Let me catch. Go ahead.
My name is Kelly Mather. I live in Sebastian, 733 North Fisher Circle. Does this come up? We agree with staff's position. Okay. The paper manufacturing, let me get my other paper out here, excuse me, is indeed a heavy industry. Chemical manufacturing is a heavy industry. And I think you're here tonight on the zoning to look at the zoning. Brick, glass, tile, grass products are manufacturing. We look like we've gone through a site review on OC tonight, but they never said it wasn't a heavy industry. All this talking that we've heard, I never heard them say this is not a heavy industry. It is a heavy industry, and it belongs in IG. All cement plants belong in IG, as we've historically done in the county. And other non-metallic product manufacturing belongs out of IL into IG. The staff has done an excellent job. They've done good research. We're very proud of it. We think it's a thing. We recommend that you approve staff's thing. Thank you.
Thank you. Go ahead. One more back here.
Fred Mensing. I live at 7580 129th Street in Indian River County, up in the Roseland area, Sebastian Mailing. We need to wake up. This county has had a shortage of industry since I was a kid in the 50s. It has relied on agriculture and tourism for everybody, and for that reason, our children have to leave the area because there are not the good high-paying jobs here, and that is a fault of the people that were before you. It is time that we started looking at getting diversified industry. We are hanging here wondering if Piper will be here. We have a situation, whether you know it or not, that the Florida East Coast Railroad will be double tracking the railroad from Vero Beach to Melbourne in the next year and a half. You have a property and several properties that you're trying to eliminate future businesses which could be viable to the economy because you are getting an applause meter without getting the facts of what can be done. The modern concrete plant, if you're 500 feet away from it, you don't even know it's there. We screamed about cell phones. We got cell phone towers all over now. This is the public's thing. They come and they scream about anything that's changed, anything that's could better our lifestyle if they think they're going to be slightly affected. I go back to when Vista Gardens or Royale or whatever they call it down near what's McKee Jungle Gardens screamed and complained about the railroad when the state had the law that you could quit blowing whistles from 10 o'clock at night till 6 o'clock in the morning. I argued with the commission, you're very foolish to pass this thing. It finally got thrown out the window at the level beyond the commission, but for a little while they put it in. We didn't hear anything more out of those people when, authorities further up the road in Washington said it is the law. Railroad trains have to blow their whistle by an act of Congress from the 1870s at grade crossing. It is time that you took the projects that are out there and looked at the real impact on the community. If it is not going to air pollute, it needs to be built to create jobs. We went through a thing here right after the hurricanes because of the Chinese dam project. The concrete accelerated beyond $100 a yard. Part of keeping the price down is to have the diversified ownership. You have a situation right now that CEMEX is looking at taking Rinker over statewide, eliminating
Fred, I think we need to stick to the subject.
Well, the subject is that we as a county need to wake up that we need diversified industry so that when Piper leaves, if they happen to, we're not sitting here holding the bag because we've got 1,000 people or 500 people out of work. And it is up to you and our county commissioners to say, hey, we're going to take a better look at this. We need to have various things here that are competitive with somebody down the block and that create jobs that pay something, not McDonald's wages. You know, you get in the construction business, there's a little bit of money to be made by the employees along with the owners. And I'm asking that you put this thing on a back burner and do a whole lot more study rather than take and make this serious mistake, and particularly in light of the fact that you may be putting the county at jeopardy under Bert Harris. Thank you.
Thank you, Fred. Yes.
Good evening, Dale Simchek, City of Sebastian. I hope all of you received our letter today.
We did.
Great. And the reason I'm here is I just wanted to make sure, A, you received that letter, and B, I know that policy from personal experience is very hard to do. There's always somebody caught in the middle of your policy with a complaint or issue. So when do you do it? When this project's done, when the other project's done. Your staff makes a recommendation. I always like to defer to staff because they are the ones with the most knowledge. In their letter dated to you on June 1st, they do talk about the large quantity of materials, producing dust and noise, outside activities. You have a problem with your zoning that is affecting quality of life. It is time to tweak it. I don't know if you could put the North County map, if staff could do me a favor, where it shows the purple light industry areas. Thank you. And the reason I bring this up is that we are a municipality within the county, and I'm looking for a camaraderie and a respect because we suffered from, it was a particular project that brought this to light, and I'm glad it did because there is time for us as a county to be proactive for the residents. Light industry is closer to residential, and it will affect the quality of life of many people. If you could see, I see another, the purple area in the North County. So this particular incident and one particular project and grandfathering rights, vested rights. As I said, when you're in the middle of a policy, it's rough. They do have a right to follow their track and pursue what they have to do. And that's a different issue. But that particular issue would have impacted my city or may impact our city. There may be nothing we can do about it. If traffic were to go up Old Dixie and dump into 512, which is my city, because of a county jurisdiction, we have no control. So I'm asking you, and as we had talked about last night at our meeting, that there is a sense of helplessness from my city where we are caught with your zoning problems that need to be brought up to date. There is potential for other problems where the city will be caught again. We have asked a recommendation, and in the bottom of your letter, staff does move that you recommend that you make this decision and kick it up to the commissioners. I respectfully ask that you honor our city's wishes as well and respect the jurisdiction that we have. We are stuck within, and we would like to make sure that the quality of life of the citizens, we're not saying that you can't employ 22 people, which may be for this particular, what you consider heavy industry on a particular job site. You can employ the same amount of people in your light industrial with clean industry. We're not limiting jobs, and we're not limiting potential. We're limiting compatibility. We want to stay compatible. And so please, I hope you review this very strongly tonight with the citizens in mind for quality of life, and also another municipality asking for your help.
Thank you for your comments, Dale. Let's take a break. We're pretty close to the 90-minute mark here.
You're going to do 5, 10 minutes? 5 minutes, 10 minutes?
They don't have any more back there.
We filed a formal protest before the meeting.
Hey, Darcy, I want to go on record that you need candy in the administrative offices. If you need a donation, see me afterwards, but we got to have some candy back there.
And he's pilfering mine. She has a few other problems going.
Is Richard behind you? Is Richard behind you?
Sure, George is devastated.
Okay, let's bring this meeting back to order. Does anybody over here on the right wish to speak? Go ahead. And remember, you need to state your name and address for the record.
You heard what?
My name is Baxter Costin, and I live in Sebastian. This is the first P&Z meeting that I've ever been to.
Well, welcome.
And I've been to a lot of council meetings, and I'm not a politician, don't get me wrong. I can't believe what I've heard here tonight. You all have told all of us, not once, but a half a dozen times what this is all about. And we spent the first hour, or maybe I think it's more than that, with these people that completely defied exactly what you said. And I know that you see this and you understand it. You were threatened with lawsuits. You were told, well, if you won't let us have this, I'm not going to say the word because you told me not to do it. We're going to put a trucking terminal in there. I can't believe that, and I know you all know it, and all I'm saying is this. This is the kind of people you're dealing with, and I hope you all can understand why there is people like myself here that are interested in my residence in the county that I live in. I want to stay here. Thank you very much.
Thank you, Baxter. Anyone else from the right over here? I'll get to the center next.
I'm voting for you.
My name is Deb Robinson, 315 Great Twig Road, Vero Beach. I think there's a lot of discussion about a specific concrete plant, and the issue is not that individual plant. The issue is what is our planning across our county.
Correct.
That may have brought it to people's awareness, but I think, we've got a lot of work to do on our comp plan as far as what goes where. We got a ton of traffic issues. We got all our commercial and the Route 60 corridor. So it's not just this one issue we need to be revisiting. It's all of them. Great that something brought it up for us to look at. But, the point is not, does a concrete plant, does this specific one create dust or another one create dust? Is the use appropriate in the proximity to residential?
I think you see concurrence up here on that issue.
So if you look, unfortunately, most of our our light commercial is wrapped right along the railroad track, but then so are all the houses, because we have such a narrow corridor through most of Indian River County where we live. But so I personally hope that we revisit it. We need to be looking, the fact that you can't find adequate zoning for some of these uses makes it very obvious that we need to be looking at the whole comp plan to see where it is more appropriate. But I hope that you do take it out of this light commercial, because it's just not a good match. Thanks.
Thanks for your comments, Deb. Anybody from the center?
Yes, I'm Rex Nelson, Sebastian. Commissioner, staff, and citizens. We commend the staff for its response to the March 6 Board of County Commissioners' request to reconsider the criteria for industrial zoning and light industrial zoning. Section 911 now says light industrial district to provide limited manufacturing and promote the establishment of employment centers to urban services and facilities, the area labor force, the local industrial and business markets, while minimizing the potential for any adverse impacts upon nearby properties. I'll skip over the next paragraph because I know you have a handout. We've seen all of the industries that are affected by this proposal. But heavy process industries visually pollute because they need elevated material storage, thus exceeding the 35-foot IRC height limits. We have a long history in this county about height limits. Those twin towers in Vero Beach always remind me of that. Heavy process industries are so capital intensive and highly automated that they employ very few. Most employees receive low wages compared to light industry positions. Heavy process industries generate a great deal of noise, which has not been talked about here tonight. But the planting of vegetation has almost no effect on suppression. To be economically viable, heavy process industries usually need to operate at all hours. Freight cars need to be unloaded day or night, and is very disturbing to nearby residents. Light industry works within 4 walls of their buildings, is clean, relatively quiet, uses no elevated storage that pierce the skylines, and needs little, if any, outdoor storage. The staff rendered a logical, thoughtful, thorough report tonight, or lately, and you're looking at it tonight. No nearby residential neighborhoods will be affected by locating industrial production needed for our economy in the IG industrial general districts. No property value impacts are there either. As a means of protecting the beauty and environment of our county, we appreciate the staff's presentation and urge your approval of the IL amendments. Thanks for your time and attention.
Thank you, Rex. Anyone else from the center? Yes.
Where is he from? Where was he from?
Sebastian. He's the guy that went to Lowe's.
Hello, I'm Betty McGuigan, 11325 South Old Dixie Highway, Sebastian. And I just want to say that I recommend your proposal tonight, that as a concerned citizen, I've sent letters, and I don't want to reiterate the complaints about heavy industrial. What I want to note that in this area, there is light industrial, that is zone light industrial, that is there. There's a little gymnast class down at the end of the road. There's, awning company down at the end of the road, and there's no objections to that in the residential and the environmental area that we want. I certainly have objections as a citizen, and to a heavy industrial being in a light industrial zone. So I would really like to see, and I have a question of, therefore, to the commission, is this heavy or light industrial? And I see it as heavy industrial. The concrete plants, what is light and what is heavy? Light to me is more things enclosed in the area that are neat and that. I hate to, I won't get into, never mind. I won't say that word. Thank you very much. The other thing is I really encourage, there's a lot of people here that are opposed, but they think that one voice in the group needs to speak. I'm not always the best speaker. I may not say it all right, but I encourage everybody that's here to come up and speak in their regard.
I'm not sure that I do. Okay, we have one more person from the center.
We're not encouraging.
Good evening, Commissioners. My name is Jeff Crack, 5700 Marina Drive, Sebastian. I'm going to make one very brief point. It indicated that the 6 existing concrete plants currently in Indian River County are all on IG zone properties. Counsel for Ocean Concrete indicated that the owner or owners went to great expense to purchase property that was already IL, not IG, and I'm sorry, but if I'm going to purchase a property for specific use, I'm going to investigate what the other companies in the same industry have purchased for the same potential business. And I think at this point, yes, it would be a catastrophe financially for him possibly, but I think had he done his homework, he wouldn't have even looked to purchase that property. He would have purchased IG property that the 5 existing or 6 existing concrete plants already have, and the one potentially who is coming into the county is also on IG property. Thank you.
Interesting point. Thank you for your comments. Yes, the yellow shirt there. Name and address.
My name is Ralph Brown. I'm actually from Jacksonville Beach, Florida, but my family has property in Sebastian, and I'm speaking on behalf of them. Just want to say that the staff recommendation, as I read it, was very thorough, well prepared, and we're very supportive of that. It's consistent with the other municipalities, and it's also consistent with all the other concrete plants in the county. There was an issue raised in terms of by Todd Smith, I believe it was, in regards to an analysis done on density, looking at population density around other plants and population density around where they were talking about citing this one. Certainly the 2 plants I'm familiar with in Vero Beach that were there when I was a kid have been there for 40, 50 years, and the city basically grew up around the plants, so I don't really see where that would be relevant. But it is very clear when you look at light industrial and it's sitting next to residential land, which is the case in Sebastian, and look at the use that it was really intended for, then it clearly emphasizes why you would not want to put concrete plants in light industrial.
Thank you for your comments. Anybody from the left over here? Go ahead.
Good evening. I'm Chris Pontello with WF McCain and Associates. I'm a consulting engineer and local business owner. This matter came to my attention this week, and I read the proposed ordinance and the staff report, and I had some concerns about it. I just hit on them real quick. This railroad corridor is the only place for this type of business. Whether it's zoned IL or IG, this type of business should be located along the railroad where the materials can be delivered easily without using trucks. Basically, the comp plan and the LDRs as they exist today allow this type of use. The applicant purchased his property with the understanding that this was an allowed use on the property, and I don't think it's right to change the LDRs. You know, you're saying you're tweaking the LDRs, but really what you're doing is you're changing the intent of the comp plan and trying to get this type of business away from that railroad corridor where it was originally intended to be.
Let me correct you there. We're not changing the comp plan.
You're not changing any of the words in it, but you're changing the intent of it by tweaking the LDRs to limit us.
We have been tweaking these LDRs for the last,
I
don't know how many years.
The LDRs are there for a reason, and it's to ensure integrity. Consultants like myself and Todd Smith that spoke earlier, we are held to a certain level of integrity by the LDRs, and we feel that the county should be held to that same level of integrity. When you have an application in-house and you're coming up on the point where the comments are going to be addressed and the permit is going to get issued, you shouldn't just pull the rug out by changing the codes and affecting a project that's been in-house since late 2004. You know, the original pre-app was at the end of 2004. So this thing's been a long time coming. Also, you know, it's supposed to be a staff-approved permit. There's not supposed to be a P&Z approval for this application. There's not supposed to be a county commission approval. It's a staff-approved permit. I'd like to encourage you, if you go ahead and make this recommendation, to consider grandfathering in the existing applications. I just think it would be the right thing to do. Thank you.
Thank you, Chris, for your comments. Anybody else from the left over here? Our left, actually.
Good evening. George Mabe, Ocean Concrete. I think I would just like to clarify the fact that I truly did do my homework. This process started for me about 4 years ago. At that time and currently today, light industrial permits concrete plants usage, and prior to even closing on the property, I fundamentally worked with staff, worked with my engineer to not nail down the fact that it was dead set in stone that it would occur, but it looked as though everything was in place that we could move forward. So I went ahead, purchased the property in 2005, and could I get the flow charts put up, please, on that? We've spent considerable amount of time here. I've totaled about 45 different professionals at this point in time working on the design work. We've been in TRC twice. I think we've shown without a doubt that we're fully committed to this thing. Again, you say that I think the issues should be clarified, whether or not what are the parameters of light industrial versus IG. We clearly see, again, downtown Vero, numerous plants side by side. The density of population in the area is twice what it is where I'm located. So I have to question the fact. I think there's much more work needs to be done defining what is IG, what is light industrial. And could you put up those slides, please, for me? Yes. I mean, the flow charts we put in just to show the extent of where we've got here. I mean, this is years of work for us right now. Could you go back to the engineering, please? Next. Technical design. This is the type of work over the last couple of years that I've had to put into this thing, and it's available for review for everybody else as well. But, I mean, again, just to change this thing at the last minute for me as I'm ready to come out and obtain the permit and move forward on this would be devastating to my business, devastating to my family. I've got my life into this thing. It's not, I don't have 3 or 4 of these. This is my first plant. Been in this industry for 25 years. And I truly believe I've done my homework correctly. I've relied on the laws and the codes in this county to come in here as an investor, as a small businessman, to move my company into this location. And I think that if, again, just to finish here, should this thing be retroactive to my project, I think it would be sending a terrible message to any investor coming into the community. There's enough risk as it is in trying to start a venture like this. If you take this and factor it into the equation, it's astronomical. So I trust that you will make a honest and fair decision in my behalf here, and we'll let it go at that. But thank you very much. Good night.
You're welcome. Anyone else from the left? Anyone else, period? Okay, then let's.
Jay Bumpers. I own some property on Oslo Road, near Oslo Road.
You need to state your address.
Address 1750 11th Street Southwest.
Okay.
Okay. I am a developer, and when I go into an area such as this one right here, and I have done that in the past here, I developed Oslo Road Storage, built that. I depended on the fact that what was there was there. When I bought the property, it was zoned for my use, just as these folks are doing that very same thing. I did all my homework. I made sure that the zoning was in place. My engineers backed me up with this. We went forward. We spent a lot of money, not anywhere near what these folks have. But bottom line is, you're going to scare away a lot of developers like myself or any business person that wants to come in here and do something, because you guys are changing the rules after the fact. You should grandfather this in. Thanks.
Thank you for your comments. Anyone else? Okay, I'll close the public hearing. Oh, I'm sorry. The public hearing is now open.
Specifically says that they're not grandfathered in?
No.
Good evening. My name is Norma Cox, and thank you for allowing me to speak to you.
Address.
My address is 6308 River Run Drive, Sebastian. I have a background in healthcare. Health of the population is really not being mentioned tonight. Any heavy industrial project does affect people's health. The stresses of the noise, there's lights that heavy industrial plants require. There is a question as to the measurement of air quality. We've heard some proponents for this plan indicate that it's 99.9% pure. I've spent today looking at the measurement tools, and they are projective equations. The parameters have to be very, very precise. There doesn't appear to be any avenue to measure air quality in Indian River County at this time. There are lots of people who will do it as a private project, but there don't seem to be any state agencies. So I'm not sure if this designation for heavy industry is retained, that the promise of clean air can be delivered to the population. I also ask you to think of one of the main industries of this area, or it has been until recently, is looking after or recruiting the elderly to live in these houses. They will not thrive in an atmosphere that is noisy, gritty, and unpredictable, and they won't buy, or they'll leave. So I think you need to look at all parameters and keep in mind that heavy industry in this day and age is highly automated, and it will not provide a huge number of jobs, just limited economic profit to a few people. Thank you.
Thank you for your comments, Norma. Anyone else? Yes.
Good evening. My name is Carol Barry, and I live at the City of Sebastian, 708 Fisher Circle, and I'm here to inform you of my fear that the face of our beautiful Sebastian could be changed forever should you allow heavy industry in our city. I love Sebastian. I love Indian River County. Sebastian is not very big, therefore heavy industry would surely affect our homes, our schools, our businesses, and I believe our spirit. I'm sure the people of Sebastian know we need industry. We do. But we don't need the kind that would hurt us. Shouldn't a business be a welcome part of our city, of our county? Is it so easy for industry to dictate what we should or shouldn't do in our county? We are not just a crowd or a group of citizens. We are a community of people who love and live in Indian River County and Sebastian. There are no do-overs. Heavy industry is not a slight change. This is our home. Please help us save us from heavy industry. Thank you.
Thank you for your comments, Carol. Anybody else? The public hearing is closed. Discussion?
I have one thing I'd like to bring up. Mr. Smith actually brought it to my attention that there's a possibility that maybe we should be adding trucking terminals to this list that should be dictated in, should be just an IG. And I'm seeing Mr. Keating say, no, it's not a good idea. Can you tell me why?
Actually, I'm not sure what a trucking terminal is.
I tried to find it in the definitions, I couldn't find it either.
If it's a warehouse or a facility with a lot of trucks like a warehouse, that's exactly what is envisioned in IL. The manufacturing facilities where the manufacturing occurs indoors, but there are trucks coming up to loading docks or warehouses, those are IL.
So like Macho, that kind of stuff.
Yeah, which have a lot of loading docks out there and a lot of truck traffic, yeah.
I think one of the problems is that maybe do we have this defined somewhere in here, Bob? I could not find a definition for some of these.
What we do is all of our uses, as Brian indicated, are referred back to under what's the old SIC, Standard Industrial Classification. It's now NAICS, but that has definitions, it's got categories. We always can go back there and refer to it. So if you want to look at trucking terminals, we could use that book.
And also, just by way of example, I think a distribution center is a pretty classical type of the more modern term for trucking terminal. I think some of these code terminologies were from the 70s and 80s, back when this code was initially developed.
There's a trucking terminal off of Kings Highway in Fort Pierce where freight trucks are stacked and awaiting distribution. It's a small warehouse with trucks. So it's not easy to define, but I'm not sure it doesn't meet light industrial. As I perceive it, which is what we're dealing with tonight, is perception, I'm afraid.
Well, when Mr. Smith brought up the suggestion that maybe they would, could do a trucking terminal, it was, I took it as saying, that's a worse use than a cement plant.
A pig farm?
Therefore, that's why I thought that maybe trucking terminals should be looked at if even he considers that to be a heavier use than the cement plant.
I happen to agree with, this is a tough call from my perspective, but I agree with what Deb Robinson said. This is, we go through all of these codes, et cetera, and continually we're turning up more and more precise projects that maybe people do like or dislike. Whether we like ocean concrete or not, I believe the concrete plants probably are closer to heavy industry than they are to light industry. I went through the same thing with packing houses. Big new packing houses are closer to heavy industrial than they are to, they're permitted in ag. So we turn up these things as we go. The staff is supposed to interpret as best they can, assimilate the information and interpret the median area. Now, this is not listed. It's listed in the code as a permitted use. Whether it's grandfathered tonight, personally, is not what I would consider tonight. I would support a motion that says that we're going to change to the staff's position, but I don't have a date certain in mind. The reason I don't has to do also with the fact that along the railroad tracks is what I consider the toughness of this, is that homes, people live along the railroad tracks, but the reality is that the railroad was there for transportation years ago. We had packing houses along the railroad. We have a lot of industry developing along the railroad. At 3 o'clock in the morning when that horn blows and you happen to be the house next door, I'm more power to you. I'm glad I live further away from the railroad, but you got to wonder if the railroad isn't more inclined toward industrial uses than it is to residential uses. And since the early stages of development in Sebastian, Vero, et cetera, they've developed around the railroad and houses have grown up that way. So I'm not going to say whether your quality of life living near the railroad is good or bad. But the reality is that's probably an area for industrial use. But I do believe that concrete plants, paper manufacturing, heavier uses should not be in light industrial uses. Whether or not this applicant comes back and says, okay, I want to apply for heavy industrial, I'm along the railroad, et cetera, that's a whole different issue. But for tonight, the issue is, in the county, is this a heavy versus a light industrial use? I would support the fact that it is outside of what I perceive light industrial.
Bob, let me ask you a question. If the commission approves this and it goes to the county commission, then can the applicant take up the issue of grandfathering at that time? Because I know that we can't. That's not, ocean's not an issue here. That's outside our parameters. Right. When that goes before the commission, then they would have the opportunity to entertain the grandfathering issue.
Yeah, the board's got several options it can do. First of all, it can determine when the effective date of the ordinance is. It could be that the soonest it can be is when the ordinance is accepted by the Secretary of State in Tallahassee, but it could be put out further. Alternatively, the board could determine that any applications already submitted are exempt from the ordinance, are grandfathered in, are vested. So those are a couple of options. Or, and I'll defer to George on this, they could make a determination based on the specific circumstances of an application that the equitable estoppel criteria would apply and give them vested rights. But
No, that's correct. Now, I don't think they would do that at this hearing because that's a separate matter. This is just strictly whether it's a good idea to, make the changes to these zoning districts. I think it could be a policy decision for this board to recommend whether applications in general should be grandfathered in, but that's a very generalized recommendation. As far as specifically naming, Ocean Concrete or anyone else, I don't think would be appropriate.
Thank you. I'm going to Bob, I'm going to parrot what George said basically, but it's my thoughts too. And that is that the arguments about where the other plants are, I don't think are really that relevant because, as someone said, back in the early 60s, they were there and it was a long way to the first house, as most of us know. And the population grew around those plants that are currently very close to the city limits, but outside Vero Beach's city limits. And we've developed these plans over a long period of time, the comp plan and the LDRs to go along with it. And we have this corridor, as George was saying, that is especially important in this case because it's a railroad corridor, and this applicant needs the rail for costs associated with his business. And we've set those corridors aside with commercial and with industrial, and hopefully everyone knew that. And then we build things up around those areas, and then we want to change them. And when that's what this is a change to that, those rules and regs. And I understand that. The part that really bothers me, and it's not because Ocean came here tonight so much, because that's basically what we're talking about now. I didn't hear that much talk about the specifics of the change, although staff did a good job of that, but still it ends up being this specific issue. And this individual, the applicant, in good faith, does everything correctly, and I've made this speech before, and invests as an entrepreneur at a high level, and then finds out that those rules are going to be changed. And even though I'm going to vote for staff's recommendation, I definitely feel that this should be grandfathered. Myself personally, I know it has nothing to do with tonight or the vote, but I just can't see the fairness associated with us doing this. I understand everyone in the audience that's here and is against it. I certainly understand that. I wouldn't want a concrete plant next to my home, but well, I didn't want Millstone next to my home, but they're there. But it's a strange situation for a commission to be in, I believe, but it's the way it is today.
Well, I was kind of impressed by the attachment 6 and the survey of other jurisdictions, industrial districts, and concrete plants with other counties here. And it looks like we're kind of out of step of Brevard County. Our neighbors, Martin County, Lee County, Sarasota County. So I think this correction is justified. And I support staff's recommendation.
Thank you.
I would concur with the change on the LDRs, but I also feel that the applicant had good faith in making the application that he did at the time that he did. So I would like to see it. I would like to see him grandfathered or some other arrangement made. I also feel, as George Hammer indicated, that rail line is an essential industrial arterial, and sooner or later that whole thing has got to be addressed, and the more residences that are along that railroad, the harder it's going to be to address.
I'm totally in agreement with changing this. It should be this way. However, I'm really upset that we're pulling the rug out from a piece of industrial construction that followed all the rules, jumped through all the hoops, and suddenly we changed the rules after he's made his application. All of you know that you have the right to develop your property as you wish, and when you buy a house in a single-family residential, you buy it there because you expect not to have a concrete plant put next to it. But here we have the opposite, where a person bought a piece of property specifically because they wanted to build commercial on it, and at the time he bought it and planned for it, just as you bought and planned for your house, he was well within the rights of the law to build that plant there. He's got caught up because the rules are changing, in the process of changing. And that's not fair, darn it. That's just bloody not fair. I would like to see something on here, an asterisk put on here for this when we send it to the county commissioners. I am going to support the change, but I'd like to see an asterisk put to grandfather them in. We've done it 100 times before on residential when we halted everything there was, but we had anybody that was in the pipeline, and then we gave them X number of weeks behind that to apply. And I think that would fit here, and that's only being fair. If we do it for residential people, we really ought to do it for the same courtesy for the commercial people. Thank you, Mr. Chairman.
I would request that we keep these two issues separate in our voting. I really think they are separate issues.
I'd like to make a motion that we, to approve staff's recommendation, send it on to the Board of County Commissioners with a request to approve staff's recommendation.
Do I have a second on that?
I'll second it so we can discuss it.
Okay.
The reason being is that I agree with this thing on the grandfathering. People have heard that as a term. The reality is that we can make that as a recommendation if we want to, but the reality is that the Board of County Commissioners will set a time certain for this, good or bad. They can hear our discussion we make when we vote yes or no. We explain our position. You've heard our discussion. You've heard several people say they think this is unfair to cut this off. I think from a legal standpoint, good or bad, I think, is it Jeff? And I'm not an attorney. We've seen our attorney's interpretation. There's a definite question as to whether application versus permit. So I think we're dealing in, you all may have a lawsuit, you may not. I don't know. But that's, we don't. We oftentimes give the big decisions to the big boys upstairs where the big bucks are paid. And whether we have a grandfathering clause like Craig indicated in it or not, doesn't really matter to me, because the reality is it's going in their laps anyway, guys. So
right.
I can live with it or I can live without it. But I think I do believe, as property rights standpoint, that they have done, he did his homework, good or bad. It's in our code the way it's written. And I think that he has every right to at least fight for this all the way to the top. And I'm not sure he won't get it. But the reality, I think in the county, it's a good decision to change this because it'll prevent all this in the future. Doesn't help today, but I think that reality is that it's probably heavy industry and needs to come out of our code. We just hadn't identified it after 30 years. We come up with these things all the time.
Yep, we've done this numerous times in the past. Any other discussion? All in favor?
Aye.
Aye. Passes unanimously.
I vote no.
Oh, you do vote no?
Yes, I vote no. I want my asterisk. I think it's unfair. All I'm asking for, or all of them, anyone are asking for, is just to bring it to the attention of the Board of County Commissioners. I can't support it without that asterisk.
Okay. Anybody else? I'm sorry, I just assumed.
Can we have we're going to vote on this one, right?
I think we just did. We just did.
I'd like to make a motion to recommend.
Why don't you pull that mic a little closer?
Sorry about that. Like to make a recommendation to recommend to the county commissioners that these people be grandfathered. They've complied with what they set out to do, and they shouldn't be just rejected for that reason.
Can that motion be that that it should be that you're asking the Board of County Commissioners to consider their grandfathering, or you want it to be definitive?
Well, I'd like to make the recommendation that they could they're going to consider it one way or the other, definitive or not. I'd make it definitive.
Okay.
I'd rather see that taken up with our attorneys and the Board of County Commissioners.
That's what I'm thinking.
I don't think that's, right now, all we're doing is we're changing an LDR as to when and how they're going to impose it. I don't think that's my decision at this point.
Yeah, I can't support that. We've made our point. I made my point, and it's going to go on the record, and that's where it belongs. I'm going to let it stand as is.
Okay.
I want to ask you, the attorney, a question. I'm a little confused here. We're voting on the recommendation brought before us.
Yes.
We're not voting on Ocean.
No.
That's my.
But
That's my point.
And is it correct to carry forward with our recommendation that it be grandfathered?
I think it would be correct, and it would be a legislative decision. I would hate for you to narrow it to one specific applicant, but I think you can say anyone who has submitted their applicants at the time of the change is grandfathered in, is vested in. I think that is within your discretion. I would not recommend specifically naming out, but I think it is well within your discretion. It's as a legislative function to create that. It's been done in the Florida statutes. The legislators have created vested rights provisions with the DRI process, as long as the common law vested rights that go along with it. So it's definitely a legislative function. It's just whether you choose to do that or not. But I would ask, I would think that you wouldn't want to make it specific to a specific applicant.
Do you want to make a motion on that?
Well, don't we have a motion on the floor right now? Does
I
it
think
die
it's
because
I think it's died for a second.
It's died?
Excuse me, there was no public discussion on this portion.
Hey, wait a minute. Please be quiet. We're discussing up here.
I would like for the motion to be that we approve the recommendation of staff and that
Wait, we've already done that.
Okay. So it's a second brand-new motion that a consideration by the commission would be for consideration of applicants that are already in process would be grandfathered in. So I'll make that motion.
Okay.
Well, wait a minute. I'm confused now. We have a motion that
George has died for lack of a second.
I know, but before that, we had a motion
on the staff.
We had a motion to approve the LDR change, and that was approved.
And we did that.
Okay, did we already? Okay, we got that over. And I just want to make sure mine was a negative vote. Did that get on the record? Great.
Sorry. Do I have a second on that?
Dies.
Okay, I think we've done this twice.
We've done our job.
Are we finished with this item?
Yes.
Okay.
Okay, next item.
6A. Okay,
screaming right along.
Rest here just a second while everybody clears out.
Where were you at golf yesterday?
I played golf today. I actually played at Riamar. I didn't play yesterday.
George, why don't you take this next item?
Yeah, I'm going to let him. I hadn't even read it. Stan, would you tell him what I said?
It was yours.
Okay, thank you.
It was yours.
I know, but I was busy reading this other thing on the way into the meeting.
Yeah, up the sidewalk.
Oh, okay, hang on. I thought whatever they recommended, I thought it was a good idea.
So just put down whatever you want.
I got another, while you're talking about it, just because you all need a little something else to do, I've got a whole nother issue that I need to bring up.
We're going to move that down.
All right.
But it's important.
Let the agenda items go first.
I'm going to miss George Christopher, but you still got a lot of Georges.
Okay, can we take your discussion outside, please, so that we can continue with our meeting?
Okay.
Go ahead.
Go ahead.
All right, Mr. Chairman, the first item under Commissioners' Matters, consideration of LDR amendments for mines and agricultural areas. And Mr. Hamner brought this up at the last P&Z meeting, and so all this really is to lay out a potential LDR amendment for mines and agricultural areas based on the last application you all had. And so the idea would be if you all are in agreement, if this reflects your wishes to treat some agricultural areas the same way that residentially zoned areas are in relation to mines, that the recommendation would then be for staff to, your recommendation would actually be to the board, to ask the board to direct staff to initiate an LDR amendment, and that's been done by the P&Z in the past on other issues. And just 4 quick bullet point items in the memo that we prepared, and the wording that's before you all are in regard to buffers and days and hours of operation. Treat agricultural areas the same as residential areas where you have 5 and 10 acre parcels. And those areas, the reason staff picked that as a criterion was that's where you either have existing ranchettes or potential future ranchettes laid out. And then the other 2 items deal with compliance bonds and increasing the road maintenance bond to bring those both into play to provide more security and really more of a stick in keeping roads up to speed, because we've had some problems with some operations in that regard.
Now, I wasn't at this meeting, but my understanding is that this issue has come up numerous times.
The reason I brought it up is that unfortunately, I've been here long enough to go through several sand mines, and almost inevitably, every one of these issues that are addressed tonight comes up for some reason or another, unless it's way west of town in an area that was unencumbered by any, at those times, potential housing.
Okay.
But as we get close to 95 with the building, and it may be potential expansion in the county, we're going to drop into agricultural areas that have ranchette potential or ranchettes approval or et cetera. And as soon as you do that with homes and houses, then buffering, hours of operation, littoral zones, they all become important. And we may as well, I'm thinking that we tend to restrict or put restrictions on them when they get there, so we may as well do this up front so everybody knows it from the beginning. And I think it's not encumbering them overwhelmingly, but I think it's pretty straightforward. And let the staff come up with an LDR so we all know where we are.
Does it make sense to do this for all sand mines?
Mm-hmm.
Oh. I mean,
it's only sand mines. The way it's intended here was in areas where you have potential for housing. If you go, and I'm not sure where this will be in our county anymore, but if you go out at a point where there's just pure agriculture, it's 40 or 50 or 100 acres, and there's not been subdivisions or whatnot, then it would go back to the original rule.
Why not just go ahead and anticipate that happening?
Only because of maybe the buffering. I mean, you're asking for some additional expense here that may or may not be required.
Well, maybe it could be worded in such a way as to say that if it ever happens, you're required to put this buffer in.
This is special exception anyway, right? Which is why we can add all of this.
Well, these are administrative permit uses, which is why
We have the
you
right
can add
to-
some of these conditions, and staff completely agrees. If de facto these are going to be added when they get to P&Z, it's best to put it in the code so everybody knows up front. I think the issue that we have here.
The point is, we still have a say-so, even on those land, eventually, the same thing comes up currently, but we still have a say-so in the future, even in any sand mine.
Well, there also actually may be ag on large parcels in this county for a long time. And so I think we may run into situations. Imagine that. Well, we may run into situations where we don't have
nothing else.
Ranches. And if you have houses on 20 or 40 acre parcels, we feel there's built into that a lot of separation. They're probably farming something between their houses.
This, I think, is a good first step. That was all.
I think it's a good first step, too, definitely necessary. I'd like to see staff perhaps pick out some other, not go through the list and pick out 100, but, we had the same thing with a non-compatibility with a kennel. So why don't we look at some of those issues when we look at the sand mines and try to take care of those at basically the same time?
Any other sensitive ag areas?
We're always going to have problems outside. Well, we're going to have problems inside and outside the urban service area. That's why we're all around. Yes, but outside the urban service area, and we've been saying this for a long time, just because it's true everywhere. We allow residential outside the urban service area, and really, I think farmers need that. They need the financial ability to do that, and people like to live out there. And so the more people over time, the more people we have outside the urban service area, the more conflicts we will have, because that's where we have some very non-residential type of uses, which makes sense to put them out there, such as mining, kennels. I mean, there's ag industries. We've got a lot of things that go and can be compatible out there. So yes, we could. I'm just saying it's a very long list. That's actually why we've tried to set several of these up as administrative permit uses or special exception and go through the criteria. And I guess, Mr. Smith, your point was maybe we need to reevaluate. How many of those uses are there out there that we need to reevaluate the criteria on?
If you come across any you remember from the past, you would have our blessing to go ahead and try and figure it out.
Controversial issues.
Any other discussion on this item?
Does this take care of the problem we had in the last one where the turning lane was a problem because there wasn't room?
I didn't go into the turning lane because it's hard to.
Because that was a problem there with that particular.
But you still have a say-so, even if we've done this list. We just we've got some more criteria on the table that everybody has to deal with before they get to us. I don't know how you'd go. I mean, I'm not sure how to add turning lanes or traffic.
Can't be done.
Well, yeah, we did a pretty significant analysis on that. And I think we came up with some criteria where it's warranted. The last one we talked about, there'd be one car every 10 minutes, I think. There were 6 cars an hour, which is, I think we brought up before, you've got trade-offs. This is a pretty expensive improvement to do. And when it's 6 cars, I think the analysis showed that it's not really warranted from a traffic standpoint, and it's a burden from a financial perspective. So I really think we'd beat the turn lanes to death.
Right. But I think you still have I think the point is that on any given sand mine, you still have a say. You still get to look at it in an individual way. You get to pick it apart. And you get to pick it apart or talk about it. So if you hit something, then we can deal with them individually.
But these always come up.
Do we need a? Is this something? Do we need a motion
we need a motion
on this?
Yes. Go ahead.
Well, I would so move that we do what I said so.
Okay.
Are you saying you want to?
I think we ought to do that. We should add this to an LDR on the sand mines.
Okay.
Items.
Do I have a second on that?
Third.
Good. Do I have a vote on this?
Aye.
Aye.
Any opposed?
Who did you vote no?
I voted.
Everybody voted yes. Okay.
Very quickly, before you go to 58, if I could, while it's under me, the thing I wanted to address was the
when we had, it's in citrus right now, you all have read a lot about canker, you've read a lot about greening. Greening is a disease that literally kills trees. Canker was something we thought would kill them. It didn't kill them. It just lowers production. Therefore, it makes it financially not feasible to continue, or could. But greening is a real issue for us right now. And the state, because of the lawsuits that we had, are probably not going to go into an eradication mode. Everyone is scared to death of that. However, as a county, I don't know if we can put this under nuisance or some form or fashion where if a neighbor, someone, we identify trees in a household or in an abandoned grove that have greening, if we could require that they're removed, or with a fine or without, I don't know, but we need to look at doing that. The other thing is that under fly-free fruit, on the Caribbean fruit fly proposals, we've limited what you could put in new subdivisions, where it's not we're not encouraging planting of host plants for flies that create a problem in citrus. Under greening, the problem is an aphid, and aphids thrive in things like orange jasmine. We've got another list of plants that if you all are willing, we would like to see put in, at least to limit and kept out of new subdivisions, so we could keep the numbers of aphids down in hopes that we can control this. But I'm not, and so those.
If you can just give us that list, I think we can.
You're going to get a letter out of the league to the commission, and I'm just telling you all, this is something that's going to. We don't have any specifics tonight, but if the county is willing, we would like to work with the people in ag, not me, someone who's smart that can figure this out. Would be great. And I don't need a motion. I just wanted to get it on the table.
I think we can put any additional pest plants under the Caribbean fruit flies. We don't need to change anything.
You just got to deal. Aphids are it's a whole different list, but same thing.
And if you want, we can, unless George wants to render an opinion now, we can go and research the issue of whether or not we can require grove owners or landowners to remove.
I'm only asking that you research it. I don't need an opinion. I wasn't looking for that. So, George, don't tell me you can't do it tonight. Wait for a while. But I'm just looking to see that it happened, if we can. If we can figure out some way to help, or at least make awareness or something, we'd appreciate it.
It might be a tricky issue, because I know the state got into trouble for eradicating trees, and I know there are a lot of
But the county's much stronger than the state.
Yeah. And so we'll take a look at that. And also, I think we might need to take a look at the Caribbean fruit fly issue, too, to make sure that's covered well enough in our statutes. And
now, 58th Avenue is much more pressing for you all, but we got that started. Thank you.
All right, this item is, I asked for this item to be put on the agenda. It's a discussion about State Route 60 and 58th Avenue. And I just want to explain, because some people here have not been through some of this, I'm going to explain why it's on tonight. We have I've almost said improvement projected for that intersection, but I'm not going to call it an improvement. We have some changes made to add some lanes, where we're going to have to buy a lot of property that's going to be very, very costly, do a lot of changes to the tune of about $22 million. And does that include moving the electrical station?
Electric station, I think, was 5.
So we're about $22 to $27 million just to make these changes to the intersection of Route 60 and 58th. Now, we understand that a traffic engineering firm looked at this with the idea of, instead of making these changes to the intersection, maybe doing some alternative routes to keep traffic from going through the intersection. I mean, there's only so many lanes we can put at this intersection. There's $22 to $27 million is a lot for one intersection, where all we're doing is continually feeding more traffic into that intersection.
Donna, you just have to learn to walk faster from corner to corner, that's all.
George, I can't, because you're driving like a bat out of you-know-where through that intersection. So some of us up here had difficulty really comprehending that spending $22 million or $27 million or whatever to change this intersection, that the money couldn't be spent better constructing alternative routes, 4-laning 26, doing more eastbound and northbound, southbound highways,
putting 66th Avenue in north and south, creating east-west roads so that people can get where they're going without maybe having to go through that intersection. So I just know that we had a problem understanding that an engineering firm would say that, no, it's better to spend $27 million on that intersection. And we really wanted to discuss that. So, Chris, it doesn't make sense.
I'll do the best I can. My name is Chris Moore. I'm the Assistant Public Works Director for the county. What I've tried to do tonight is give kind of a status report on the intersection, where we are, where we plan to go in the future, and also cover the alternative corridor study that was performed and recently submitted to the county. The three areas I want to cover: current conditions, the future improvements, and the corridor study. First is under current conditions. The intersection itself, State Road 60 and 58th Avenue, over the years has gradually increased in traffic, and you can see the daily traffic numbers there before you from 1994 on up through 2006. The intersection itself in those 12 years has gone through about a 69% increase in traffic. That AADT represents annual average daily traffic. That's the daily traffic entering the intersection on a typical weekday workday. So in 12 years, gone up 69%. The county, compared to the county average of about 43% increase in those same 12 years. So what that means is that the traffic at that intersection has grown a little bit faster than the rest of the county. Certainly, it's a commercial corridor. It's a magnet for shoppers, retail, commercial, and that's probably why it has increased at a faster pace than the remainder of the county. Currently, during the afternoon peak hour, which is the hour that we measure concurrency for, the intersection operates at a level of service F. We have 6 levels of traffic service, A through F, just like the old report cards, A being the best, F being the worst. Our level of service standard in the county is D, so anything worse than D fails to meet our county level of service standard. This is at F, so it fails. So the bottom line is, yes, the intersection's over capacity as we currently measure concurrency. To give you some idea of what level of service means in more easily understandable terms, well, it means very high volumes. It means lower speeds because traffic congestion tends to slow down vehicles. It means multiple cycle failures. Cycle failure means you don't make it through the light in one green light. You have to wait to get several green lights, more than one, to get through the intersection. Increased vehicle stops and starts, long delays, forced flow. Forced flow is kind of a engineering term, but it means that instead of traffic flowing through an intersection smoothly, they get a green light and they flow through in nice organized platoons. Traffic tends to force its way. It kind of squeezes through an intersection. As soon as a green light comes available, they kind of squeeze through and they don't all make it. And lastly, in the realm of public safety, crashes may increase. I say may increase because it doesn't always happen that way. And I'll get into that a little bit later with the accident rates and statistics. One thing that most people mention and complain about at this intersection is the northbound left turn. The northbound left turn from 58th Avenue onto westbound State Road 60. It's very heavy, it backs up, you get a lot of cycle failures, and the reason is there's 731 lefts per hour. That's the second highest left turn volume in the entire county. What's the first? First is, I knew you were going to ask me that. Southbound Indian River Boulevard onto southbound US 1, right at 4th Street, where we have the triple left. That's about 840 per hour. That's the only one that's higher, and that's really more of a through movement in that it's the end of Indian River Boulevard. It's not true left, but my point is that all of these movements at this intersection, all the left turn movements, northbound, southbound, and so on, all are very high. Now, as intersection designers will tell you, when you get over 100, you put in a left turn lane and give them a green arrow. When you get over 200, you put in dual lefts. When you get up in the 400 or 500 range, you need triple left turn lanes just to move that mountain of traffic that you're trying to get through. If you look at the accident history over the years, it's actually gone down. A number of crashes and the severity of crashes have actually gone down. In the mid to late 90s, we were averaging over 20 a year, 20 crashes per year. We completed the last widening project in 1999, and the accidents actually dropped. And they've stayed down below 20, except for that 1 year, 2002. I don't know what happened there, but we had a spike there. But generally, they've stayed down under 20 crashes per year. If you look at the rate is actually a more meaningful number for engineers because it equates volumes and crashes. This is the rate in crashes per million vehicles entering the intersection, but that has also dropped. So even as that slide before I showed you, the ADT has increased over the years. Number of accidents and, more importantly, the rate of accidents has actually gone down. Why is that? We really don't know, but we think it's because increased congestion results in lower speeds, which results in fewer crashes, better reaction time, fewer crashes, and we've worked hand in hand with the sheriff's office to get better enforcement out there of red light runners, left turn red light runners. If you've been through the intersection the last couple of years, you probably noticed we've wired white, we call them enforcement lights, underneath the red lights. That gives officers a better ability to pull over red light runners because they can sit on the downstream side, see when the light turns red, and chase them down on the downstream side rather than follow them through the intersection, run the red light themselves, and then risk injury just pulling them over. So the white lights, the white enforcement lights have also helped us. The traffic signal, we've done about all we can. We've got all modern equipment out there. Everything is ITS, now Intelligent Transportation System enhancements. We've got fully actuated controller, all the left turns are signalized, full pedestrian signals, fiber optic cable, white enforcement lights, computer controlled. Everything pretty much follows our coordination system on State Road 60, which is inbound in the morning. Traffic is coordinated towards the center of Vero Beach, which is US 1 and 60. And then in the afternoon it reverses itself and traffic is coordinated out of the city or westbound on State Road 60. This signal is part of that coordination system. Future improvements that we have programmed for the intersection include widening all four approaches to the intersection. What we'll be adding is we'll have east and westbound dual left turn lanes on State Road 60. We don't have that now. We just have single lefts. North and southbound on 58th Avenue will add right turn lanes. We don't have those now. Also, north and southbound on 58th Avenue will add the 5th and 6th through lanes so that we'll end up with 3 through lanes northbound and 3 through lanes southbound for a total of 6 through lanes. Southbound dual lefts, we already have that, but northbound will actually have triple left turn lanes on 58th Avenue to handle those 731 lefts every hour in the peak hour. This is the lane configuration that we have now. This is what we'll have in the future. The red arrows and lanes there are the additional ones. And this is a true expanded intersection. This is a typical expanded intersection with dual lefts, 3 throughs, and a right all the way around, with the exception here that we're adding a 3rd northbound left turn lane to make triple lefts. This is the intersection as it appears today. A little bit closer look there. You can see the backups northbound.
Is that Google Earth?
No, that's actually one of the county aerials. County has very good aerials these days. You can snapshot them and pull them into a report like this. They're very nice. But to get this many lanes in that intersection arrow that you just looked at, what we would have to do is pull back the edges of the pavement to approximately where these red lines are shown on the aerial.
Yep, there they
And you can see they encroach oak trees, they encroach green space, they encroach parking areas, they encroach businesses.
Walmart, I know we had some discussion about creating space there. Has that happened?
Well, we have gotten the right-of-way dedication from Sam's. I think we've handled about 2 Sam's Walmart, but not Walgreens. We're still working with them. That's still in process. This is a view of the expanded intersection, kind of superimposed over an existing aerial. And I'll close in on it here a little bit. This shows the expanded intersection with the additional turn lanes.
I think I'm in Miami.
You are.
Just walk fast.
The intersection improvement project, it's a county project. The design is currently underway by a consultant for the county. Plans are about 65%. Right-of-way acquisition is also underway. It involves about 35 parcels we've identified so far. There could be more, though, as we finalize the design work. So far, we've counted up approximately 2 more acres of land that would have to be purchased by the county to accommodate that intersection. We anticipate construction to begin in 08-09. Estimated project cost, now this is outside of, this includes the 2 acres of, let me back up. This includes construction costs, utility relocation, the 2 acres of additional right-of-way, but not business damages. Those are still a bit of an unknown to us. We have to deal with all of those 35 parcels. We'll know more about business damages as those negotiations go through.
The electric transfer station.
This will not involve the electric transformer station on the east side across from College Lane. This is only for the transmission facilities that run up and down the east and west side of 58th.
But that will have to be moved, won't it?
Not with this project, no.
Okay.
That was the point.
Available funding that we have in our current CIE is shown there. We've got traffic impact fees, gasoline taxes, developer contributions, and we've got a grant from the DOT. It's a regional traffic grant for $3.8 million that DOT is kicking in on this project also.
Chris, so you got 15 million, you've almost got to that in revenue.
Yes.
Is this a kind of a project where you have to have every dime in the bank before you can start the project, or can you have separate phases of it?
Well, the project will be built in one phase. It'll be about probably an 18-month project. Could be longer if the utilities straggle a little bit, but the funding is actually spread out over a couple of years, and while we're collecting that funding, we're also getting developer contributions along the way. That figure that you saw, 0.3 million for developer contributions, that's just what we have received so far. There'll be more coming in, and we're doing applications all the time with developers to collect additional funds on that. The alternative corridor study. In October of last year, the county hired a traffic consultant. What was happening here is the board began to see that the additional costs, and this board here began to see the additional costs, the high costs associated with the project. So they started to take a more long-term look at this intersection. What would be the best way? Do we really want to add all the lanes? Do we really want to spend that kind of money? Might it be better to evaluate other corridors? So the county hired a consultant last October to look at alternative roadway corridors that could take some of the traffic off this intersection and maybe reduce the scope of it, maybe not have to add so many lanes. These are the 5 routes that they evaluated. It's probably easier to show them on the aerial, but the first route, Route 1, was a north-south connection between State Road 60 and 26th Street in the vicinity of 50th Avenue, just east of 50th Avenue. There's a
Is that a creation of a new road?
That'd be the creation of a new road.
There's a piece of property there, I think it's zoned multifamily and then residential on the back.
Right. We kind of went out of the box on this one and started looking for areas where a road possibly could be punched through if the right-of-way could be purchased and the design of a roadway could be done in that area. That's the first route. The second one was actually an extension to the east of College Lane through the step-down transformer station that's there, and that's a big-ticket item. That's about a $5 million hit to move that station. But again, we're thinking out of the box, extend College Lane to the east, bring it along the north bank of the Main Relief Canal, and then twist it north a little bit, right around the east side of Sonny's there, Sonny's Barbecue, and pull it up to where it could maybe intersect with 60 and pull some of that traffic away from the intersection to the east. Another route, Route 3, that we looked at was an additional north-south connection between College Lane, just north of the community college, between College Lane and State Road 60 in the Flora Lane Head Place area.
Is that where the existing stoplight is coming out?
Yes, right coming out of the mall. That's where that traffic signal is.
Yeah, that'd be great.
Another route we looked at was a connection, actually an extension of College Lane south and west, again along the north side of the Main Relief Canal, but extending west to line up with 16th Street at 66th Avenue. That would require rebuilding that bridge over the Lateral A Canal, which runs along the east side of 66. But actually, the community college has stepped up here, and we're looking to funding that with them and getting that road built anyway.
Why the south?
Why go
West?
south?
Why not just head straight out to 66?
That community college owns all that property there, and they have, in their master plan, they have
What they wanted
development.
was you to go around that. Okay.
Right, exactly.
That's a shame.
Being realistic again, George.
That's a shame.
And then the last route was to actually make another connection down to 12th Street. This route could actually be substituted with the extension of 66th Avenue to the south down to 12th Street, which the county is going to be building within the next couple of years. So that Route 5 could be slid a little bit further west. The key would be to route traffic away from 58th Avenue far south enough that they could then move north and connect either along the Head Place, Route 3, or maybe continue up 66.
But you don't show 66th Avenue in there. Why not?
66, and if Brian is still here, he can maybe help you. I think you kept 66. You felt 66 was a given for all the routes, didn't you?
Oh, that was in the background because it's under the
Right, because it was in our
place.
Right. So they figured that would be in place.
Did you do 4 lanes north, or did you do 4 lanes or 2 lanes? I'm just curious. North of 60, did you build into 4 lanes in the alternates, or did you just keep it 2 lanes? Because currently we've got a plan to go 4 lanes to the north and 2 lanes to the south, or 4 lanes to Oslo.
It was put in the model on 66 extension as a 2-lane between 60 and Oslo, and 66 north of State Road 60 would remain
2 lanes. I see.
There's a multitude of other improvements that were included on 26 and on 43rd.
But that was your assumption when you did all these other alternative routes.
Two lanes, I believe, right?
Chris, when you're coming from the east and you get to Sonny's, and the thought is then that people would not want to go through the 58th and 66, or 58th and 43rd, so they would drive out there by the college to get back on Road 60 and or to go to the mall? I mean, is that what the idea is?
Well, the idea, it works both ways. If they're coming from the east and maybe don't want to go through the intersection but want to head to point south, they've got an alternative. Or if they're coming from the south and they don't want to go through that intersection but maybe want to head east on 60 or go to Walmart or Sam's, they can head in that way. There'd be connection along the back road there. It's designed to kind of siphon traffic away from the intersection in all the quadrants.
Chris, did you consider that suggestion I made about going between Lowe's and Office Depot and connecting up to 26th through that stormwater?
Through that area, no, we didn't include a route in there, although that's a possibility of
And I think a lot of people would take that route to go to the mall if it existed.
They go the back way now. I mean, they do go up that 26.
Well, not when you're going to Lowe's or Office Depot or so forth, right in there. I mean, there's some issues you'd have to fill in that stormwater retention a little bit, and you'd probably have to take out one house on 26 or so.
Well, I think there are some developments coming in along the south side of 26 there.
There are.
Sunnyside up and some others that are going to be making a connection. It would be through a development, but they'd be making a connection.
I would take that path. It would certainly help me, but I don't know.
But it might give you a connection to 26 further east than taking the Mall Ring Road all the way around and takes you out too far west.
That's the whole idea. I won't go that other way because it just takes me forever getting through the parking lot.
Well, did all this help or not?
That's what I'm getting to.
Oh, okay.
Study results, construction of the 5, you read my mind. Study results, construction of the 5 alternative roadways resulted in a moderate, in other words, between 5 and 15% diversion of traffic away from the intersection. And the consultant's conclusion was that the alternative routes do not provide sufficient diversion to reduce the planned intersection improvements. Now what they did is they looked at 3 different years, 2006, 2016, and 2026, and grew traffic out, looked at the growth rates in the county, looked at how this intersection would behave if these planned diversion routes were in place, and they just couldn't get enough traffic siphoned away to bring the level of service back down to an acceptable level.
What would be the number, you or Brian, what's the number that would be meaningful? I mean, we're at 721, is that what I saw?
For the left turns.
The left turns,
right.
the left turns, it was 60.
That was just the left turn.
So
right.
it's 68,000.
Yeah, the ADT was around 64, 65,000.
So 10% in the 6,000, 9,000, 15%. I mean, do we need to get, how low would we have to get? What's the break point?
I think
to be meaningful enough to do this, because I appreciate the engineering here, but people, pressure does, we may get to 20 without realizing this, because people just will literally avoid that intersection.
Brian, you want to take a stab at that? I don't know if you really looked at that in terms of a break point in traffic flow.
No, we didn't. Unfortunately, as Chris mentioned, the results said, Chris outlined the 5 routes that we looked at, and we looked at combinations thereof. We looked at all of them. If you built every one of them, what impact would it have? If you built, 1 and 2, what impact? A lot of different combinations thereof that we evaluated. And within I think it was 6 different combinations, none of them resulted in a sufficient amount of diversion to then justify a reduction.
Did you look at did you have any cost estimates on
Well, that's what I was going to get to.
I know there's some serious right-of-way
Yeah, I've done some real rough, and these are very rough numbers. We're talking about those 5 routes that you look at right there. They represent about 8 to 9, between 8 and 10 lane miles of new roadway, of which no right-of-way has been acquired, or very little right-of-way has been acquired. Utility relocation with the transformer station there on the east side of 58th, across from College Lane, be very expensive. We're looking at probably somewhere in the area of 50 to 60 million.
No right-of-way?
For those, this is total, construction and right-of-way and utility relocation.
Your guess at just pulling a number out.
Yeah, I'm just pulling out, I'm using averages for lane mile construction estimates, but this is not cheap either, and it's much more expensive than the State Road 60 and 58th Avenue improvements, probably on the order of 2 to 3 times as much.
So it's a rough order of magnitude, actually.
Right.
Is this not something, though, that, like it or not, we make? Let's say we go to the construction of 58th Avenue, and we bottleneck that intersection now, Well, where are we going to go?
Well, you got to remember, some of these we're pursuing anyway. 66th Avenue paving and extension, we're pursuing that anyway. That's going to take some off the intersection.
You're working on College Lane, maybe between the two?
Right. College Lane, we're working with the community college. We're working to extend that out to 66th. That is going to take some load off the intersection. But I don't, it's staff's recommendation that we don't give up on the intersection or reduce the scope while we're looking at these other routes.
Is the route south of Walmart and Sam's and hooking in at Sonny's, just that portion, is that an expensive, I mean, is that right-of-way and all, would you perceive that to be expensive?
Well, it could be, because we don't know what our conditions are going to be when we get in there next to the main relief canal.
And you also have the power station, the
Right.
transfer station.
Right, and with the main relief canal so close, they may tell us you don't have clear zone to put a 2-lane road there, which means we may end up having to pipe or bridge that.
I don't think
So
that's
it's-
ever going to happen.
It could be very expensive.
What is the reticence of the college to go just straight line College Lane?
They have a development.
They've got, I think their master plan shows a library and other facilities, and they're going to.
Right, including the joint library.
Okay.
Years ago, they, indicated they didn't want the thoroughfare, cutting off a lot of their property there. They're looking at they're going to, hopefully, they hope to have a lot of walking between different buildings and such, and they didn't want a thoroughfare.
You don't want to split the campus, the future campus.
So what about 8th Street and some of these others? Did you consider those?
We didn't consider that far south. We were just trying to stay in the quadrants immediately around.
Seems to me that would be where you'd want to put, that would be less expensive. So what costs would it be to pave 8th Street?
Well, there's costs involved in paving any of these roads, but you've got to remember, we're trying to divert intersection traffic. The farther south you go, the less you're going to be able to entice people to use it to divert around that intersection.
Well, if you're trying to get out to I-95, and you could, why don't you have the east-west traffic go through 8th Street and maybe some of these others?
It's true, but you've got a route right now. If you want to use Oslo Road, a paved route all the way out to 82nd, and then north on 82nd, you can go paved road all the way to I-95.
Yeah, but of course you have to drive down to Oslo. So if you don't want to do that, that's out of your way. To go down to Oslo. Why would you want to do that?
We would still want to pursue putting other routes to the west,
I would
8th
think
Street,
that would
4th
be,
Street, and so on.
Stay away from 58. What you're doing is just putting more emphasis on that that area. You're building up that area. So eventually it's going to be, I don't see how you're going to win in this whole situation.
Yeah.
That and the fact is when you go to construction, where are we going to go? How many fingers are going to be flipped at those cameras at that intersection?
Chris is off.
You want to get people away from 58th and 60th.
Commissioner, we did include the extension of 12th Street over to 66th Avenue. Essentially, the limit was 26th Street down to 12th Street, the 43rd Avenue to 66th Avenue. That square, if you will, is the area that was.
Well, that was the limit of your modeling.
Within the modeling, yes.
So how much did it cost? How much does it cost to do 8th Street?
I couldn't speak to that right now.
12th Street.
Yeah, I'm saying from a modeling perspective of trip diversions. In the model, 12th Street was connected all the way over to 66th Avenue.
But 8th Street should be, should be easy to figure out the cost. You're going to.
I just don't have it readily available.
We asked about that about a month ago.
I guess the dilemma, though, that's what I was just asking. If it's to do all these in particular, but it's 50 or 60 million, I guess that if you go 8th and 12th like you're talking about, which I'd be in favor of, because I'd certainly use it. I'm out that way. It saved me a lot of time. But if it only diverts 5% out of the intersection, you still got to do that intersection. And that's the worst part.
Right. You got to remember where the attractors are. You got to remember where the attractors are. The attractors are at 58th and 60. They're not west of 66th.
And we keep putting more in.
Yeah. But wait a minute. Now, there's a lot of people that go through that intersection that aren't going to attractors. They're just trying to navigate through there.
Right.
So, I mean,
I think if
don't.
you can get somehow get 66 built from Oslo Road through and a way to get to 66,
Yeah,
even if it's only 12th and not 8th, I think people going north to Sebastian, you'll see that road pick up considerably.
66 is going to make a big difference. We
I think
think
it'll help.
that.
And if 43rd gets built, it's 4-laned or whatever, and 27th in town, I think we'll see some diversion of traffic in there as well.
Why are we only two-laning 66, too? I mean, that's...
Well, we did a lot of travel demand forecasting modeling with the MPO. We looked at the bigger area, the entire county. Brian looked at a smaller area, and we are eventually going to 4-lane 66 from State Road 60 down to Oslo. And the travel demand forecasting model showed with a 4-lane road, it really attracts a lot more traffic over there.
Yeah, when we were evaluating 43rd Avenue, expanding 43rd Avenue to a multi-lane facility was a huge attractor within the modeling software.
82nd will help going out to 510.
Right-of-way acquisition on 66 is going to have enough for 4-lane. I mean, we're already there.
Right, we're getting
5
enough
years ago,
right
we
away
already
for the
planned
4
that
lanes.
for the right-of-way,
ultimately.
right?
It's just that we're only building 2 lanes at the present time.
66th Avenue, though, north of State Route 60, is becoming a main thoroughfare into Sebastian. And right now, you've got a lot of people making left turns that are just blocking traffic. I mean, this is a road that can take traffic off of US 1, can take
Another
traffic...
left turn lane.
Well, at least 3-lane it. Jeez. There's no plans to widen 66 north of Route 60?
Yes, we have 4-laning plans for 66 north of 60, all the way up to
When?
Barbara Schuman.
What's the time frame on that?
That's in our 5-year plan. It's probably about, you have some of those design plans, don't you? Are they 60%?
There's 2 consultants working the segment of 66 you're speaking of which 60% plans on both segments have been submitted to the county, and the county is actively pursuing right-of-way acquisition to facilitate those improvements.
All right, and another northbound route, on 58th, from south of 60, I see you've got, in your projections, you've got 3 lanes going straight through the intersection at 60 and 58th.
That's
You've
correct.
got 3 northbound lanes going up 58th, but that all goes into 1 lane.
No, they'll be going into, it's 4 lanes right now. 2 lanes northbound, 2 lanes southbound, up past
just to the
26th
next
Street.
intersection.
Up to 26.
Up to
only.
26,
After
and then what
26,
we'll be doing is, we'll be slowly bringing those 3 lanes back down to 2 lanes, and that will ultimately be 4 lanes northbound, north of there on 58th.
So you're going to 4-lane 58th also?
Right.
And is that in the 5-year?
That's in the 5-year plan also.
Okay, so that got put back in. All right. So, it doesn't look like we have an easy fix.
The key here is learning to drive in the next one. The key here is learning to drive in the next 5 years with all this construction going on that they're going to do.
Oh, yes. There will be alternative routes found while this construction is going on. But thank you very much for explaining to us so that we understand what we were hoping would be a good move, maybe isn't quite monetarily sound.
Could we have a copy of your presentation?
I don't have hard copies with me, but I can get those to Darcy and
Why don't you just
distribute them.
email us the
Email the
PowerPoint?
Oh, I can do that, yeah.
That's fine.
That's fine, Chris, thank you.
Thank you so much for your time and trouble, Chris. I
Yes,
really
thanks
appreciate it.
very much, Chris. One other thing, I'd like to introduce our new member, George Lawrence.
Thank you.
Welcome aboard.
Thank you very much, Mr. Chairman.
Condolences.
Yeah. Any other commissioners' matters? Planning matters?
Mr. Chairman, it's time to talk about buckets.
Yeah. See if that'll hold water.
A week following the last Planning and Zoning Commission, I worked with George Christopher to kind of to follow up on the tasks that we were given at the last meeting in May, and that was to reorganize a bit of the matrix that we'd come back to you all that lists out the 52 ideas that were given at the April 25th workshop on improving the quality of development. And so that breakdown is reflected in this revised matrix. And a couple of things I just want to point out about this. One is there are a total of 52 ideas. As we indicated before, 42 of these staff is committed to inputting into the EAR process, even though there may be some other avenues for getting input or making LDR changes or what have you. We think 42 of them do go into the EAR process, and that's being handled by staff, and staff has a responsibility for seeing that occurs. A couple of other things with these buckets or these new categories. I think one of the reasons that Mr. Christopher wanted to break it down this way was to try to assign some responsibilities, some areas of expertise and interest and responsibilities. Yep. And so you'll see some Planning and Zoning Commission member names thrown out here to be liaisons or people who would maybe have some expertise in an issue, or would kind of help see that these issues get shepherded through and at least considered in the appropriate way, and just basically follow up on them. Dr. Baker being one with water issues, as been outlined. The idea here was also Bob Bruce on some environmental ideas. Some of the green initiatives. Board of County Commissioners Peter O'Brien will probably be reporting back to the board on that, and that's kind of an area that he's addressing. The architect group, local AIA group, has said that they will help work on architectural issues. The idea that's in that part of the chart is to invite them to come back to you all to meet together amongst themselves and maybe staff, and come back to you all in the fall and present some items. In the environmental areas, perhaps invite Dr. Cox and the Audubon Society to look at some of those issues and come back to you all in the fall as well. Those are some of the kind of the big picture ideas, I think, that were associated with the way that Mr. Christopher saw these kind of getting broken down to at least have some areas of responsibility. It's really up to you all. It was your workshop, and how you want these handled. Again, I just want to emphasize staff is looking at handling most of these actually through the EAR process. I don't think you all have gotten to the level yet of whether there are any of these 52 ideas you want to just exclude and not address, not spend the time and effort pursuing or not. So I think at this point in time we're open to however you all would want to handle these, and however much time or when you want to handle these.
Stan, the 12 that are not, or 10 or 12 that are not included in the EAR process, are those identified somehow?
Yeah, I think that what you would do from here, well, first we have, I think, the last category being the remainder. I think those didn't fall neatly into any category. That's 9 of those items, and only 2 of them we saw fitting into the EAR. So there's 7 right there, 7 of those 10 that we don't have plugged into the EAR. I have to admit I don't have the rest of the matrix committed to memory at this point, so I couldn't point out the other 3 immediately. But you just check that first item. Like,
are they under the review committee where it's blank? Is that where we?
No, the first column in the matrix says EAR implementation element. If we've got an element identified, it would plug into the.
Okay, so if you're plugged in there, then we're going to see this in the EAR. So it's only when it's blank in there that we need to. Okay.
That's right. And again, some of these may be addressed through the EAR, but there may be other initiatives that are already going on. We could conceivably see some issues come to the front on green buildings, for instance. Water supply issues are going to be talked about next week. That'll certainly plug in the EAR, but there may be some county projects that get more support or go through there. So, some of these may actually get addressed on a couple of different levels simultaneously.
In as much as this, we've got the bucket straight now. I'm just wondering if we shouldn't take this back, review it, and then And maybe talk about it another meeting, because it's late.
That's what I was going to
I don't,
suggest.
because I don't, unless somebody has specific interest in any one project, I mean, I think it's kind of hard to identify without, now that I understand the way he did this, what he.
This is a great start.
Right.
This is the way,
Yeah, I
this
think
is
so.
the broad stroke that you have to take before you start
You and
anything.
George both need pats on the back or accolades, because it's, I mean, this is taking a lot of time to get.
You have to, this is
Put
an
into
excellent way to start. This is the only way you can start these big projects. You got to put something on paper.
Is Mr. Christopher staying involved in this?
I hope so.
After I went through this, yeah, I think he's certainly very interested in this. He wanted to make sure that he completed this task, because he committed to do it at the last meeting. I emailed this to him. I think he's actually been out of town, so I haven't gotten any direct feedback from him, but I think this is pretty much represents things. I don't know how much more input he's going to give. I really don't. Certainly.
Have you given George Lawrence backup material on this so that he's up to speed?
He has the meeting packet.
Okay.
But we haven't specifically gone in. We've met once, but I haven't specifically gone into what happened at the workshop and that.
You got the minutes of the special meeting that was called?
We've not given that to him specifically.
That would be a good thing to do.
Right.
Is that videotaped?
Yeah, I believe it is on video online. Which would be even better, because
get together now after my first meeting with these guys again, and
Get
there
brought
are a
up
few
to
things
snuff.
that I need to do.
Right.
A few things that I need to do on that kind of.
Right. The video presentation, I haven't looked at it myself, but there was a lot of graphics used at the workshop. It'd be really good to see those. We don't
Right.
have all those yet.
Okay. All right. I think what I'm hearing is that we're going to go digest this, and we'll have more discussion. If you'll put an agenda item on the next meeting also.
Anything else you all need from us, or what I'm hearing is you want to just look over, now that you understand how it was put together, look at it, and then we'll just discuss it the next meeting? Is that?
Yes.
Okay.
Great start.
Okay. I think the next item, we're not supposed to do anything with this. It's just information. The EAR, all these meetings.
You all have to know.
Attorney's matters.
Nothing at this time.
Okay, I think we're adjourned then.